And no arguments?
I don't know. I don't have the picture for one of them. Trying to see. Did you try to look?
I think we can hear you now, Judge.
Oh, can you hear me?
Yes.
Yay, okay, great. Yeah, they were logging in some way.
It's the black box that we used to use. Is it just inactive now?
Used to be like on the record, off the record.
Yes, yes.
Okay.
Get in there.
Okay. I can listen in. He's just gonna figure out. what's
Okay.
wrong with that. But they can.
All right, but that's all I need to touch
Right.
for now. Okay. All right, we are officially on the record. It is June 9th, 2020. This is Judge Wish. It is, I am in courtroom 1 at the VRC, and we are videoing to VRC courtroom 2. And can I have the parties please announce themselves for the record, please?
Letitia Fowler with the Office of Public Defender.
All right, Ms. Fusco, you can go ahead now. Okay. And Ms. Fowler, you're over there with your clients, and so it may be difficult with Ms. Fusco being here just because in terms of talking over each other. So I just want to make sure that we try to not talk over each other. If we do, we'll try to figure out a way to get that resolved. Okay.
Okay. Yes,
All right. How you doing?
I'm good.
Okay. Okay. All right. Okay. And then I know yesterday, I was advised that the court reporter had some difficulties hearing people. My guess is it may be because you're all in masks and some headgear and all sorts of things. So the only way I can say to do that is maybe lift your head and speak the microphone instead of talking through. You know, if you want to keep that on, you can. It's really up to you.
I think the you can hear me.
I am having trouble hearing you from just being right here.
There's nobody within 6 feet, so maybe.
Right. No, I mean, I'm fine with whatever you want to do. It's really within the discretion of the judge to allow people to take off their masks or not. So if you want to wear the mask, you can wear the mask. If you do not, I have no problem. There's nobody around you, Ms. Fusco. Okay?
It just depends if you can hear me. Can you hear me?
I
better
can
now?
hear you when you speak into the microphone.
Okay.
Okay. All right.
And we're starting with the move-ups or Spanish, Judge?
We'll do the move-ups first.
Okay.
Now that we're connected, I don't want to start another issue.
We have move up and resets and then the Spanish.
Yeah.
They looking at me mad, like she bonded. I'm just telling you what the other people say.
All right. Can you hear me, ma'am? Good morning.
Yes,
All right. Can you tell me your name, please?
Nellie Amber.
All right, Miss Amber, you're here in 2020 CF 7136AO. You were arrested pursuant to a warrant in which probable cause was found for first-degree murder on a disabled person, aggravated manslaughter on a disabled person, aggravated abuse of a disabled person, neglect of a disabled person, and abuse of a disabled person. And I will appoint the public defender's office to represent you in your case. And count 1 is a punishable by life, or it's a capital offense. Ms. Fusco, did you wish to be heard as to bond?
Yes, Your Honor. The defendant was aunt and caretaker of the victim who was deaf, mute, had cerebral palsy, and had to use a walker or wheelchair to get around and had to rely on others for bathing, eating, the activities of daily living. The state asked the court to consider all the facts in the affidavit, including the blood spatter in the bathroom where family members say the victim was regularly restrained, attempts to clean blood evidence at the scene and dispose of the body and other evidence, old and new ligature marks and injuries to the victim, the autopsy which showed death to be homicide due to asphyxia from restraint compression to the abdomen, evidence regarding use of restraints, items used for restraints found in the trash compactor area at the apartment after statements made by family members. The state asks the court to find proof evidence or presumption great that upon commission of an aggravated abuse of a disabled person, the defendant caused the death of the victim and holds the defendant at no bond.
All right, and then Ms. Fowler, did you wish to be heard?
Your Honor, we defer the matter to the court on the issue of proof evident presumption great, but we ask for the court to take into consideration the lack of criminal history.
Okay. All right, based on my review of the affidavit for arrest warrant and admissions, I do find that there is proof evident presumption great. At this time, I am going to hold Ms. Ambert at no bond on count 1, and the Public Defender's Office can file a Arthur hearing motion downtown for that to be heard in the trial division. And so bond on count 2 will be $10,000. Did you need me? Hold on 1 second.
Yes, she is. Okay, she needs to be next to the public defender. Okay, but you can hear the defendant's tone and you can hear the state and you can hear the judge. Okay,
So the court reporter cannot hear Ms. Fowler.
okay, thank you. Bye-bye. She needs to be close to the microphone.
Ms. Fowler, the court reporter cannot hear you at all.
Is this better, Your Honor?
I could hear you. It was the court reporter. My guess is that you need to be directly in front of a microphone, so that was louder. So hopefully we resolved that. But I believe you said you defer to the court on the matter and would ask me to take into consideration a lack of criminal history.
Yes, Your Honor.
Okay. So, and I am going to hold Ms. Ambert at no bond on count 1, $10,000 on count 2, $5,000 on count 3, $5,000 on count 4, and $5,000 on count 5. No contact with any of the witnesses or co-defendants that are charged in the case. No contact with any member of the victim's family. No weapons or firearms or ammunition, and no drugs or alcohol without a valid prescription. Did anyone have anything else they wanted to place on the record?
No, Your Honor.
Okay, all right. Good luck, Ms. Ambert.
Your Honor, next on the list is Brown, Stephen Brown. He is mental health.
Okay, so Mr. Brown is mental health. I am gonna appoint the Public Defender's Office to represent Mr. Brown. Ms. Fowler, did you want to waive his appearance?
Yes, Your Honor.
Okay, so he's charged in 2020 CF 7124AO with carrying concealed firearm. And I do find probable cause. I did appoint the public defender, no weapons or firearms or any ammunition. The bond will be stayed at $2,500 or pretrial release if he qualifies for that. Good morning. Tell me your name, please.
Good morning, Devon Harvey.
All right, Mr. Harvey, you're here in 2020 CF 7140AO. You were arrested pursuant to a warrant in which probable cause was previously found for attempted first-degree murder with a firearm. And that was premeditated, attempted aggravated battery with a firearm, and count 3 is attempted aggravated assault with a deadly weapon. And I will appoint the Public Defender's Office to represent you. Count 1 is a punishable by life felony. Ms. Busco, does the state wish to be heard as to bond?
Yes, Your Honor. The state asks the court to consider all the evidence in the affidavits, including the videos retrieved, surveillance video from the scene, and recorded statements on video to find presumption presumption great the defendant committed attempted first-degree murder with a firearm and hold the defendant at no bond.
All right, and Ms. Fowler, did you wish to be heard?
Your Honor, I defer the matter to the court.
Defender's office. She didn't have the police report because this was a move up and it wasn't on Odyssey. That's why I came over to read it. And we have no argument.
Okay, and then, I'm sorry, I think you all were talking over each other, so you just want to place your name on the record, Ms. Custin?
Aaron Custon on behalf of the Public Defender's Office,
All
Mr.
right.
Harvey.
Thank you so much. All right, so I did review the affidavit. I do find proof evident presumption great as to count one. And so I am going to hold Mr. Harvey at no bond on count one. Count two will be $15,000. Count three will be $7,500. Mr. Harvey, your attorneys will file a motion for you, and that will be heard in the trial division downtown. So no return back to where the offenses are alleged to have occurred, no drugs or alcohol without a valid prescription, no weapons or firearms or any ammunition, no contact with any victim or any witness or any of the victim's family members, and no contact with any co-defendants as named in the affidavit or any information that may have been filed. And I believe I did state the bond. So your attorneys will file that motion for you, okay? All right, good morning. Can you tell me your name, please?
My name is Christian Matias.
All right, Mr. Matias, you're here in 2020 CF 7137. You're arrested pursuant to a warrant, and probable cause was found for tampering with or fabricating evidence and false information to law enforcement in investigating a missing person. And so I will appoint the public defender's office to represent you in your case. No contact with any of the victim's family members, and no contact with any witnesses or any co-defendants as named in the affidavit or any information. The bond will stay set at $3,500 on count one. Count two, I'll reduce to $150. If he has not been interviewed yet, so I will also do or pretrial release. Mr. Mateus, if you qualify, okay?
What?
Well, the victim is deceased, so it would be no contact with the victim's family members, witnesses, or co-defendants. And did corrections get that, the or PTR if qualified? Okay, thank you.
Your Honor, the next person on the docket, DeAndre Medley, will not be coming to court due to behavior.
Okay, so I'm gonna find that as behavior as a waiver. I'll appoint the public defender. Ms. Fowler, did you want to waive?
Yes, Your Honor.
Okay, so he's charged in 2020 CF 7099AO with possession of cocaine. I find probable cause 2020 CT 3691, no valid driver's license, and I find probable cause. I did appoint the PD in both of those cases. No driving without a valid driver's license, and no drugs or alcohol without a valid prescription. Mr. Medley has not been interviewed for pretrial release, so it'll be bond or pretrial release. If he qualifies, it'll be $1,500 or PTR. All right, good morning. Tell me your name, please.
Alain Perez.
All right, Mr. Perez, you're here in 2020 CF 7122AO. You're arrested for robbery, sudden snatching, and assault. And I do find probable cause for those offenses, and I will appoint the public defender to represent you. So no return back to the Dapper Dock at 28 South Orange Avenue, no contact with any victims or witnesses, and no weapons or firearms or any ammunition. And so the bond will stay at 3,100. All right, good morning. Can you tell me your name, please?
Good morning, Carlos Harris. Yes.
All right, Mr. Harris, you're here in 2020 MM 4165AO. You were arrested for trespass on property after warning, and I do find probable cause. You want to try to resolve your case today?
Yes, ma'am.
Okay. Is there an offer, Ms. Fusco?
Yes, Your Honor, adjudication of guilt 2 days for 2 days credit time served, court costs, no return to the scene of the trespass at the Alden.
All right, so Mr. Harris, it's credit for time served, and no return back, and you can't go, you abide by the trespass warning. Hold on, we've got another issue with the audio, I think.
She's completely lost her. She can't hear anything.
So the court reporter can't hear any of us at all.
Recording going on right now. So she's gonna contact AT.
So what are you trying to tell me? What are you talking about?
You hear that?
All right, we're gonna have to hold on. We can't do anything until we're back on the record, okay?
Oh, you want to talk to me?
So are we supposed to call somebody?
She said she's gonna call AT.
Okay.
I'll give her a few minutes and then I'll call to follow up.
I thought coming back here was gonna be good. I think it's on their end because we can all hear each other.
She said she's free 7 minutes. She'll contact me.
Okay.
We're able to hear everything from the court reporter who called, and she said that she couldn't hear anything. She lost everything. Okay. No. Yes. I already know she asked me to call you as well. I have to call you back. Okay. Okay, thank you.
Who's that?
That was AB, so I'm sending her, asking her to back up.
Sorry, folks. We're trying.
Okay, I just wanna fill it out.
Sure,
Okay.
filling them out.
Well, I just wanna put his name on it.
Sign.
Yeah, but,
Sign things.
just to make sure we get both case numbers on it. Yeah, I'm just gonna do it. I'm not gonna have him sign it. Because we're gonna take care of one that's not on the docket. And- You get
Some
internet?
connection, some connection.
Are you there?
I'm working on it.
17 this new year, so he's good probably. As long as he doesn't have any.
Okay,
Hard to breathe.
okay, no problem, no problem. She said I was just throwing it up here. But she's calling AB.
Should I disconnect and then reconnect?
You can call.
I'm gonna try that. All right. Can you all hear me over there?
Yes, Your Honor.
Okay. We can, now we'll see. That helped? This is Judge Wish. Hi. You can hear? Okay. I disconnected and then reconnected, so that might have been. Okay. All right. Thank you. Okay. We are back on the record. Okay. Mr. Harris, we were talking about resolving your case today. So the offer was credit for time served and no return back to the location where you were trespassed.
Okay.
Do you want to accept that offer?
Yes, ma'am.
Okay. And did you read the plea form before you came into court?
Yes, sir.
Yes?
I read it.
Okay. Did you understand everything that was on the plea form?
Yes, ma'am.
You understand all those rights that you're giving up when you enter the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Okay. You understand if you're not a U.S. citizen, the plea will subject you to deportation.
Yes, ma'am.
Okay. I find a factual basis based on the affidavit in the court file to accept your plea. I will adjudicate you guilty, sentence you to 2 days with credit for 2 days time served. No return back to where you were trespassed. Abide by the trespass warning.
Okay,
Order
thank
you pay your court costs by June 9th, 2021. That gives you a year. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you.
Excuse me,
No
ma'am.
action, no action on the out on release case. Yes.
Excuse me. How much do I have to pay by June 9th?
2021, it's, what is it, 323?
It's
By
320.
2021.
Did you appoint?
He did not fill out a PD form.
Okay, did you appoint?
I did not, because he did not fill
Between
one out.
2020 and 2021.
$273,
$270.
$270.
$273.
within a year, okay?
Okay, yes, ma'am.
Your Honor, as a friend of the court, Mr. Harris would
I will work
also
for
like
that.
to resolve his out-on bond case. The state attorney offered credit time served on 20.
There's no information that was filed.
Okay.
There's no information. I can't take a plea on a misdemeanor. No, not after a first appearance, I can't, without an information being filed, unless it's an MO or a CO case.
Okay, thank you, Your Honor.
Okay? Yes. Did somebody from, correct, could you all? Huh? Oh. Okay. All right, good morning. Can you tell me your name, please?
Good morning, Your Honor. Naomi Green.
Do I have, I'm sorry, Miss Green, do I have Gerald Slazeman?
Behavior, Your Honor.
Okay, I'll address Miss Green first since she's there. So Miss Green,
Yes, ma'am.
you're here in 2018 CF 1919AO. It's an on-view violation of probation, and based on the offense that you were arrested for on June 7th for aggravated battery with a weapon. And so there is probable cause for the on-view violation of probation. I will appoint the public defender to represent you in that case. The bond will be stayed at none at this time. You'll see Judge Whitehead in a couple of days for your arraignment.
Your Honor, can I say something, please?
I would be very careful what you say, Ms. Green, because what you say can be used against you. Ms. Custon her office was appointed to represent you, so if you have any questions, you ask her, okay? She can speak for you.
My client is requesting a bond be set so she can get it to her son.
I just had a baby, Your Honor. I'm not.
Well, Ms. Custon, your office is gonna have to file a bond motion for her, okay? So the bond will be stayed at none. You'll see Judge Whitehead in a couple days, but, okay? All right, and then can you tell me your name, please?
John Pinto.
All right, Mr. Pinto, you're here in 2018 CF 15495. You were arrested for an on-view violation of probation, and that's based on a trespass on property after warning. And I'll appoint the public defender's office in both the cases. So in 2020 MM 4171AO, it's trespass. I do find probable cause. And so no return back to that airport, I believe. Can't go back there, abide by the trespass warning. I'm not gonna accept or request an offer today because you are on probation. All right, so, and there is a PC for the on-view. At this time, the bond will stay set at none, and the PDs will have to file a motion. You'll see Judge Whitehead in a couple days for your arraignment on the.
Can I say something, Your Honor? So in
Mr.
terms of
Pinto,
in
Mr.
terms of
Pinto,
not having a place
Mr.
to live
Pinto,
and being
listen to me
chased around the
carefully.
street because DCF committed fraud on my mother, and you people are gonna continue to fuck me up now, right?
Okay, I'm gonna deal with Mr. Slazeman. You said it was behavior?
Yes, Your Honor. Behavior.
Okay, so I'm gonna find his behavior to be a waiver. I don't know if the state would have an offer today, but if they did, I would reset him for tomorrow. There is an offer? Okay, what is the offer?
Adjudication of guilt, 3 days with 2 days credit time served. I guess by tomorrow it'll be 3 days credit.
Okay, Ms. Fowler, did you hear that?
Yes, Your Honor. We would like to
Okay.
reset the case.
Okay, so I'm gonna appoint you guys to represent him, and we'll reset it for a possible plea tomorrow in the initial appearance. We'll see if Mr. Slazeman wants to behave and come to court.
have the interpreter cases now, Your Honor.
Okay, is this Mr. Ayala?
No, those
We
are
have,
resets.
we have a couple resets that I have. Do you wanna do the resets after the interpreter cases?
The way that the update was sent to us, it was the move-ups, interpreters, then the resets.
Okay, which however y'all wanna do it, it was just what was on my stack, so. So I'll put the resets aside. Yeah. Mm-hmm. Orange interpreter?
Yes.
Yo hablo español.
Nobody's answering. What I did.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today, Your Honor.
Okay, and are you all able to hear the interpreter in courtroom 2?
Yes, Your Honor.
Okay, and then can you just
One
make sure
moment, Your
that the
Honor.
defendant here can hear you, Madam Interpreter?
Yes, Your Honor, I'm trying to connect right now, thank you.
Okay, thank you.
No entiendo, yo hablo español. Sí.
Your Honor, he can hear the interpreter now.
Excellent, thank you so much. All right, good morning, sir. Tell me your name, please.
Pedro Bacac. Cac.
Pedro Bajacacac.
Pedro Bacac.
All right, Mr.
Your Honor,
Babcock. Yes.
Your Honor, one moment, I need to verify that the defendant speaks Spanish. One moment.
No, tengo dialecto. Quechí. Ajá, Quechí es de Guatemala. Sí, muy poquito. Español sí, un poquito. Bien.
Your Honor, this defendant is from Guatemala and he speaks a dialect. I asked him if he speaks Spanish. He says a little. In the past, we use Chitzil interpreter, his interpreter with his dialect.
Do we know what the
That can be-
specific dialect is? Because we've had issues in the past trying to get certain types of dialects.
Yes, I can make sure of his dialect, but I could tell that his first language is not Spanish.
Right. Okay, but if he understands Spanish, I'd like to be able to try to do Spanish.
Quechí.
Okay, yeah.
Quechí. Idioma maya.
That's the language that we've had issues with in the past, the dialect.
Yes, Your Honor, and since he says he speaks a little Spanish,
Yes.
I do not feel comfortable doing the plea in Spanish because
Well,
it is not his.
We're not doing a plea, but you're saying in the initial appearance?
Okay, so it's initial appearance.
Yeah,
Okay,
we're not
trial.
taking a plea today, yeah. Okay, so can you tell him that if any point he doesn't understand to raise his hand?
Bien.
Very well.
Okay. All right, Mr. Bakak, you're here in case number 2020 MM 488AW. You were arrested for domestic violence battery, and I do find probable cause for that offense. And I am appointing the public defender to represent you. I don't believe there are any witnesses here for Mr. Bacoc's case. No one is raising no. Okay, security is telling me that there's no one here for his case. Mr. Bacoc, I am ordering that you have no contact directly or indirectly with the victim in the case. I believe that is your son. I'll have you sign the no contact order that is in Spanish. Mr. Bacoc, were you able to understand what was on the no contact order?
Sí.
Yes.
All right, you're also to maintain a separate residence from your son. You may return there one time with law enforcement to get personal belongings that you may need. You're not to possess weapons or firearms or any ammunition. And I do note that the Department of Children and Families was contacted, so you must comply with any investigation. I'm also showing an immigration hold or a detainer. Can corrections tell me if that's still on, if the detainer is still there? Okay, so there is an immigration detainer. Mr. Bacoc, your attorneys will have to help you with that. I'm gonna place you on pretrial release, but they won't release you until that immigration hold has been lifted. Okay? So Ms. Custon is gonna give you a phone number. You can call that phone number and speak with an attorney. Okay? Good luck, sir. Thank you. All right, good morning, sir. Please tell me your name.
Héctor Antonio Rodríguez Serrano.
Victor Antonio Rodriguez Serrano.
All right, sir, you're here in case number 2020 CT 3668 and 2020 CT 3669. You're charged with driving under the influence with property damage to a person or another, and a hit and run or leaving the scene of a crash involving damage to property. I do find probable cause for those offenses. It appears as though you do not qualify for the public defender, but you also have an on-view violation of probation out of Pinellas County. And are we still appointing the PD? Okay, I am gonna appoint the PD on that as well as the new case, regardless of whether you qualify or not, so that you have some representation while you're here. And so one of the judges here should reach out to Pinellas County to see if they will give you a bond on the on-view violation of probation. As it relates to the DUI, no contact with any victim or any witness, no drugs or alcohol without a valid prescription. And the bonds will stay at 1,000 on each count. All right, thank you.
Pero yo no me puedo fiar porque tengo la probatoria.
I cannot bond out because of the probation.
Correct.
Porque me dan bono.
So why am I getting a bond?
I gave you a bond on the new case, not on the VOP, not on the violation, but on the new charges, you are entitled to a bond. You don't have to bond out if you don't choose to.
Pero si yo me fío, la probatoria está bien. BOP lo que van a hacer es jugarme los chavos, ¿no?
But if I bond down, the probation is still in place and I don't have a bond for that.
Correct. You do not have a bond on the violation of probation at this time.
Thank you.
All right, thank you, sir. All right, do we have any other interpreter cases?
No, Your Honor.
Okay, and then, Madam Interpreter, can you make an announcement outside in the gallery? See if anybody needs the interpreter, to please raise their right hand.
Yes, Your Honor. ¿Hay alguna otra persona aquí en la galería, aquí afuera, que necesite los servicios de intérprete? Por favor, si hay alguien aquí que vaya a necesitar intérprete, levante su mano.
Okay, I see no hands raised. Thank you, Madam Interpreter, I appreciate
You're
it.
welcome, Your Honor. Thank you.
All right. Please tell me your name.
David Ayala.
All right, Mr. Ayala, you're here in 2018 CF 9903AO, and you're charged with robbery, sudden snatching, or violation of, it's a violation of probation. The underlying offense was that offense. And so it's pursuant to a warrant. I'm gonna appoint the public defender. I don't have a form. Did you want me to appoint the public defender?
I mean, before coming, this morning my dad texted me that he already had the lawyer. I already paid the lawyer Saturday, so.
Okay, so what I'm gonna do is I won't appoint the PD today. You'll see Judge Whitehead in a couple days. If for some reason you don't have an attorney at that time, talk to Judge Whitehead about that, and the public defender could be appointed at that time. Oh, we have a notice? Okay, who is it? They did file a notice of appearance,
Leslie
okay?
Sweet.
Miss Sweet?
Yeah, Leslie Sweet.
Okay, get in touch with Miss Sweet, okay?
Yeah.
All right, thank you.
Miss, oh, never mind, it's all right. I'll just get in contact with her.
Okay, thank you.
All right. That's it?
The next person on the docket, Dennis Hellslip, he refused.
Okay, and so this was yesterday, or was reset the other day for being in the hospital. And this is an out-of-county warrant. Was the PD appointed the other day? No. So I'm gonna appoint the public defender to represent Mr. Hayslip on the out-of-county warrant. Looks like the bond is this it says ROR and then it says 0, so. And I'm looking at the teletype, it says 0.
No, teletype is a per Seminole County bond.
Sorry?
Per Seminole County bond is not.
Yeah. So, Ms. Fowler, did you want to waive?
Yes, Your Honor.
Okay, my guess is Judge Carter or another judge will reach out to them as to a bond, but I believe the bond is none at this time.
The next person on the docket, Your Honor, Maurice Williams, hospital.
Okay. Why was this reset yesterday? There's no note as to why it was reset.
Mental health yesterday.
Okay, all right. All right, so we'll reset again within 24 hours of release from the hospital. Can we just make sure that's in the notes? Thanks. Okay. All right, good morning. Can you tell me your name, please?
Good morning, Your Honor. Ricardo Gallardo.
Okay, I'm sorry, sir. I know you're wearing a mask and it's difficult, but I just need you to get close to the microphone for me.
Yes, sir. Good morning. My name is
Thank
Ricardo
you.
Gallardo.
All right, thank you, Mr. Bellardo. You're here in 2020 CF 7118AO. You were arrested for aggravated battery with a weapon, domestic violence. You do find probable cause for that offense, and I'll appoint the public defender to represent you. Are there any witnesses for Mr. Bellardo's case present?
Mr. Torres
No.
is here, Your Honor, in the courtroom.
Oh, okay. Okay, and Mr. Torres was also arrested, so let me get his paperwork. All right, and can you state your name, sir?
Joseph Anthony Torres.
All right, Mr. Torres, you're here in 2020 493AW. You were arrested for domestic violence battery, and I do find probable cause. I don't have a form for the public defender. Did you fill out a form for the public defender to be appointed?
No, ma'am. I wanted to speak for myself.
Okay, well, I don't
was-
suggest that. Okay, I don't want you to talk about what happened or what didn't happen or what's alleged to have happened, okay? So, do you want me to see if you qualify for the public defender?
That's fine.
Okay, do you work?
Ma'am, yeah, I work for myself, and I was actually working doing a job. So I was
Okay.
supposed to be
and
there
then
today, and
Do you get paid weekly or bi-weekly or monthly?
by job.
By job.
As soon as
So
I
what
finish the job, I get paid.
Okay, and so what,
Usually I get a draw. If I don't finish right then, I get a draw within 5 days.
tell me what you make every week on
Um,
average,
Anywhere from $500 to $600.
a week?
Yes, ma'am.
And that's
If-
pretty
if-
steady.
If no, it's not. It's not a study. I'm not working study. It's just when I get a job.
Okay, I'll appoint the public defender's office to represent you, okay,
Ma'am,
Mr.
I have
Perez?
excuse me, ma'am. I have a court date for on child support hearing,
Okay,
which is
I'm
on
not here-
which is on the 10th. And right now, I was on a job, and I have no money to get out of jail to be able to give some money to the judge tomorrow, so I don't end up in jail.
Okay, well, we're not dealing with that case today, okay, so hold on, all
Okay,
right?
Yes.
So, did, Mr. Bellardo, are you afraid of Mr. Torres?
No, ma'am.
Do you wish to have contact with him?
That's fine.
Okay, has there been any violence in your relationship in the past?
No, everything's good. It was okay. My uncle.
Okay, and then what's his relationship with you?
He's my uncle.
Okay, do you all live together?
Was mostly yes. Yes and no. Off and on.
Yes and no, okay. The location of the incident, is that your residence?
That's my grandma's house.
Okay. Are either of you staying at that residence?
He
I live
mostly
there.
stays there.
I'm sorry.
My uncle Joseph stays there.
Okay, so you do not stay at that residence?
I come and go.
Do you have another place to stay?
Yes.
Okay. All right, Mr. Torres, are you afraid of Mr. Bellardo?
No, I'm not.
Do you want to have contact with him?
Yes, I do. He's my nephew.
Okay. Do you think any drugs or alcohol had any involvement in what may have happened?
Just the person that he was with.
Okay.
A female.
And so you're not in fear?
No, ma'am.
Okay, all right. So does anyone else, Ms. Fusco, have any additional questions?
Nothing further.
Okay, and Ms. Custon or Ms. Fowler?
No questions, Your Honor.
All right, so I'm going to allow you both to have non-hostile, non-violent contact with one another. So no pushing, no shoving, no headbutting, no kicking, no biting, no scratching, no getting in each other's faces, no saying mean things to each other. Do you understand?
Yes, ma'am.
Okay, so when things get heated, you walk away.
Yes, ma'am.
Yes, ma'am.
Right, okay. All right, so, and I'm gonna order that you maintain separate residences. Okay, so continue to maintain separate residences, no drugs or alcohol without a valid prescription, no weapons, no firearms, and no ammunition. Mr. Bellardo, you qualify for pretrial release. I'm gonna release you to pretrial release. Would Mr. Torres qualify for pretrial release?
He did not qualify for interviews. Did you want to court order him?
I'm gonna court order you into pretrial release as well. You're not gonna miss your court date, and you don't have to pay a bond, Mr. Torres.
Thank you, ma'am.
Okay?
Thank you.
Don't miss your court date.
I won't.
Okay. All right, good luck.
Thank you.
All right. Good morning. Can you tell me your name, please?
Yes, it's Denise Edwards.
All right, Miss Edwards, you're here In 2020 CF 7110AO, you were arrested for aggravated battery, domestic violence. I do find probable cause, and I'll appoint the public defender to represent you in your case. And do we have a witness here for Miss Edwards? No witness is present. Okay. So, Miss Edwards, I am ordering that you have no contact, directly or indirectly, with the victim. I'll have you sign the no contact order form, please.
I'm sorry.
That can
Your
be,
Honor.
yes.
I
It's
didn't-
yes.
Okay,
Hold on. What are you about to say?
nothing. That's fine, Your Honor, I'm sorry.
Okay, it can be changed in writing by a judge, okay?
Oh,
It will
okay,
have to be
that's-
changed in writing by a judge at
Okay.
another day, okay?
Okay.
So, you're to maintain a separate residence. If you need to go back to the residence and the victim is present, you must go with law enforcement. You must go with them to get your belongings, okay? You can go one time if the victim is present.
Yes, ma'am.
No alcohol or drugs without a valid prescription, no weapons or firearms or any ammunition. You do qualify for pretrial release. I'm gonna release you to pretrial release, okay? Make sure you comply with my court order and their conditions.
Yes, ma'am.
Good luck, ma'am.
Thank you.
Good morning. Tell me your name, please.
Hector Andres Rosa Padilla.
All right, Mr. Rosa Padilla, you're here in 2020 CF 7116AO. It's aggravated assault with a deadly weapon, domestic violence assault, and domestic violence battery. And I do find probable cause for those offenses, and I'll appoint the public defender to represent you. Do we have any witnesses here for Mr. Rosa Padilla? No? Okay. No witnesses are present today. I am ordering you to have no contact directly or indirectly with the victim or any witnesses in the case. I'll have you sign that no contact order, please. And Mr. Rosa Padilla, did you understand everything in the no contact order?
Yes, ma'am.
Okay. You're also to maintain a separate residence. If you need to return to the residence, you must go with law enforcement, okay? You're not to go by yourself. No weapons, no firearms, no ammunition, and no alcohol or drugs without a valid prescription. If you have any weapons or any firearms, you must surrender them within 6 hours of your release from the Orange County Jail. Do you understand?
Yes, ma'am.
All right, I am placing you on pretrial release.
What is that?
You need to make sure that you comply with the court orders
What is that?
as well as pretrial release. If you have contact or you violate any of those conditions, it's a new law violation, okay?
Yes, ma'am. Yes, ma'am. Thank you.
Please tell me your name.
Jacob Brandon III.
All right, Mr. Thude, you're here in 2020 CF 7132AO. You're arrested for aggravated assault, domestic violence, and criminal mischief over 1,000. And I do find probable cause. And I am showing that you're not going to qualify for the public defender. So you indicated you make $700 a week.
Yes, ma'am.
Is that after taxes or before taxes?
It just ranges, it fluctuates, but I don't know the position of my job during the current situation.
Okay, do you have any children or dependents?
No, Your Honor.
Okay. And so when you say you don't know about your job, where do you work?
Matt Concrete,
Okay.
Stuart, Florida.
And so you're not sure if you'll have a job after today, is what you're saying?
Correct.
Okay. So I'll appoint the public defender to represent you, okay? And we do have a witness present. Ma'am, can you raise your right hand to be sworn in? And do you swear to tell the truth, the whole truth, and nothing but the truth? Okay. Can you just speak into the microphone a little
Yes,
bit?
I
Okay,
do.
thank you. Can you state your name and then spell your last name for me, please?
My name is Judy Gamache, it's spelled Gamache.
Okay. And Miss Mosh, how do you know Mr. Thude?
He's my ex-husband.
Okay. And are you afraid of him?
Yes.
Okay. So my guess is you do not want to have contact.
No, ma'am.
Okay. Is there anything that you want to tell me? No? Okay. All right. Does he live at the residence?
Yes, he does.
Okay. Is Is the lease in your name?
It's in both of our names, but it's being changed to my name only.
Okay. So what I can tell you is I am going to order no contact directly or indirectly with you, okay? So, Mr. Throot, I'm gonna have you sign the no contact order. I'm sorry, Ms. Custin, did you have any additional questions?
No, Your Honor.
Okay, and Ms. Fusco?
Nothing further.
Okay. And so, it's a no contact order. Mr. Throot, did you understand everything in the no contact order?
Yes, Your Honor.
Okay, so because he's on the lease and I understand that may be changed, I can only order maintain separate residence, but he cannot be at the residence if you're there.
That's fine.
Okay, so Mr. Thu, do you understand that?
Yes, Your Honor.
Okay, so if you need to go back to the residence at all to get any personal belongings, you must be with law enforcement. Okay, you can go one time with law enforcement to get those things, but you must be with law enforcement. You're not to possess any weapons or firearms or any ammunition. You do qualify for pretrial release, so you'll have to report to pretrial release. Make sure that you comply with those requirements as well as my court order.
Yes,
If
Your
you
Honor.
violate anything, it's a new law violation and you can be held at no bond.
Understood.
Okay? All right? Thank you, ma'am. All right, good morning. Tell me your name, please.
Donovan Fontil.
All right, Mr. Fontillo, you're here in 2020 MM 495 AW. It's domestic violence battery. I do find probable cause, and I will appoint the public, well, I don't have a form for the public defender. Were you planning on hiring your own attorney?
No, ma'am.
Okay, and do you want me to appoint the public defender?
Yes, ma'am.
You do?
Yeah.
Okay, do you work?
Yes, ma'am.
Where do you work?
I work at Best Western Hotel
Okay, do you get paid weekly, bi-weekly, or monthly?
bi-weekly.
And then what is your paycheck every, when you get it?
700, 800.
Okay, I think you would qualify bi-weekly. Yeah, okay, you qualify. I'll appoint the PD to represent you, sir. All right, do we have any witnesses here? No. Okay, so I am ordering no contact directly or indirectly with the victim, Mr. Fontil. I'll have you sign the no contact order that can be changed in writing by a judge. Did you understand everything in the no contact order?
Yes, ma'am.
Okay. I'm also ordering that you maintain a separate residence. If you need to go back to the residence, you must go with law enforcement. Do you understand?
Yes, ma'am.
Okay, no weapons or firearms or any ammunition. It looks like DCF was contacted, so they may have an investigation, I don't know. If they do, you must comply with that investigation. And I am placing you in pretrial release, okay? Make sure you comply. Good morning. Tell me your name, please.
Solis Gordon Gillespie.
All right, Ms. Gordon Gillespie, you're here in 2020 MM 494 AW. You're arrested for domestic violence battery. I do find probable cause, and I'll appoint the public defender. Do we have any witnesses here? No? Okay. So I am ordering that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order form, please. All right, did you understand everything in that no contact order?
Yes.
Okay, and it appears as though you do not live together, is that correct?
Yes.
Okay. So I'm ordering that you continue to maintain separate residences. You're not to possess any weapons or firearms or any ammunition. I am ordering that you're not to return back to that residence. And I think I said no weapons or firearms or ammunition. I did, okay. And so you do qualify for pretrial release, ma'am. I am gonna place you in that program. Make sure that you comply, okay? Good morning. Tell me your name, please.
Riley Greenwood.
All right, Ms. Greenwood, you're here in 2020 MM 4170AO. You were arrested for dating violence battery, and I do find probable cause, and I'll appoint the public defender, and we do have a witness here, sir. Can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, can you state your name for me and spell your last name?
Navar Morant, M-O-R-A-N-T.
All right, Mr. Morant, how do you know Miss Greenwood?
She's my ex.
Okay, do you all live together? Okay, are you afraid of her? Do you want to have contact with her through the pending of the case?
Yes, I don't mind.
Okay, has there been any violence in your relationship in the past?
Oh, ma'am.
Okay, it's the first incident.
Yeah.
Do you think any drugs or alcohol had any involvement?
No, ma'am. The thing was, I left my firearm in her car. I tried to retrieve it. I called the police to go up there with me to get it back. She told the police I hit her. But I have a video of her hitting me. I didn't call the police on domestic violence. I just wanted my firearm back. That's it. And she called the police and I hit her. I had a video of her hitting me. I'm like, why would you do that? Why would you do that if I didn't even call the police on domestic violence? I just wanted my firearm back.
Well,
I have no
so
problem
you're
with
telling me that you're not afraid of her?
No, I don't have no problem with it. I just want my firearm back. That's it. I left it in her car when she dropped me off home. That's it.
Okay. Ms. Fusco, do you have any other questions?
And no questions, Your Honor.
Okay, thank you, Ms. Fowler. All right, I am gonna allow you to have non-hostile, non-violent contact, okay? So, Ms. Greenwood, that means no hitting, no biting, no scratching, no kicking, no pushing, no shoving. Do you understand?
Yes.
You can't get in his face, you can't say mean things to him. Do you understand?
Yes.
Okay. And so you're gonna continue to also maintain a separate residence. You're not to possess any weapons or firearms or any ammunition. And you do qualify for pretrial release, so make sure that you comply with pretrial release. I'm gonna place you in that program, okay?
Okay.
If you violate any condition, you could be held at no bond, and it's a new law violation, okay?
Your Honor?
Yes.
The court consider releasing her on her own recognizance due to her lack of criminal history.
I'm gonna place her on pretrial release. All right, thank you, sir. All right, please tell me your name.
Brian Keith Horton.
All right, Mr. Horton, you're here in 2020 MM 4167AO. You're arrested for assault, domestic violence, and battery domestic violence. I do find probable cause for those offenses. I don't have a form for the public defender. Are you intending on hiring your own attorney?
I would just defend myself.
Okay, well, I don't always suggest that that's a good idea. But you're more than welcome to discuss that with the judge who will be assigned to your case if it gets filed on. And so I won't appoint the PD today. Do we have any witnesses here for Mr. Horton? I don't see any, no hands raised. Okay. So, Mr. Horton, I am ordering no contact directly or indirectly with any victim or any witness in the case. Do you understand?
Yes, ma'am.
Do you understand everything on the no contact order?
Yes, ma'am.
Okay, you're also to maintain a separate residence. You're not to return back to where the offense is alleged to have occurred.
Yes, ma'am.
And no weapons or firearms or any ammunition. I don't believe you live together, correct?
No, we don't, but we do live in the same complex, but
Okay.
it's 500 feet apart, so.
Okay, that sounds good, as long as you know that and you
Yes, ma'am.
comply with the court order, okay? You do qualify for pretrial release, so, and did I say no weapons? Okay.
Yes, ma'am.
So I'm gonna place you in that program. Make sure you comply, okay?
Yes, ma'am.
All right, good luck. Good morning, tell me your name.
My name is Jamal Jarvis, ma'am.
All right, Mr. Jarvis, you're here in 2020 MM 4159AO. It's a domestic violence battery. I find probable cause, and I'll appoint a public defender to represent you. I don't want you to talk about the facts of your case. If you have a question, you can ask Ms. Custon, okay?
Who Miss Custy?
Me. What's going on?
doing?
You all set?
Yep. Yes, sir.
Okay. So, Mr. Jarvis, I'm ordering no contact directly or indirectly for, with any victim in the case. I don't believe there's any witnesses here for your case, Mr. Jarvis. No. Okay. So I'll have you sign the no contact order form. Make sure that you understand it. Did you read it and understand it?
Yes, ma'am.
Okay. You're to maintain a separate residence. If you need to return to the residence, you can go back one time with law enforcement to get personal belongings. No weapons or firearms or any ammunition. And you do qualify for pretrial release. Make sure you comply with their conditions in my court orders, okay?
Yes, ma'am.
All right, good luck. All right, good morning. Tell me your name, please.
Jimmy Nicole Leroy.
All right, Miss Leroy. You're here in 2020 MM 4169AO. It's an assault, domestic violence, and criminal mischief. I do find probable cause for those offenses, and I'll appoint the public defender to represent you in your case. Do we have any witnesses here for Miss Leroy? No witnesses are present. Miss Leroy, I am ordering that you have no contact, directly or indirectly, with the victim. I'll have you sign the no contact order form. Did you read the form before you came into court?
Yes, ma'am.
All right, do you understand everything contained in that form?
Okay, Your Honor, we're ready.
Did you understand everything in the form?
Yes, ma'am.
Okay. All right, I'm also ordering that you maintain, or excuse me, you are not to return back to where the offense is alleged to have occurred, and you're not to possess any weapons or firearms or any ammunition.
Requesting a one-time return to get their kids' clothes with law enforcement?
Okay, I'll allow you to go back one time. After that, you cannot return back there, okay?
Yes, ma'am.
Your bond on count 1 is set at $1,000. Count 2 will stay at $250. Looks like you're out on release for aggravated battery with great bodily harm. And that was just yesterday, I believe, that you were released. And it's family as well. I believe it's not the same victim, but it's appears as though there's some family issues going on. So, Ms. Leroy, I am going to revoke the pretrial release and set the bond at none at this time. Does she have the PD in the other case? Okay, you do have the public defender in the other case. So they'll be able to file any appropriate motions for you in the other case. All right.
Here you go. Call that, okay? Thank you. I highlighted it.
Okay, and how?
I have no clue either. Okay?
All right, good morning. Tell me your name, please.
Wayne Robinson.
All right, Mr. Robinson, you're here in 2020 MM 4172AO. You're arrested for a violation of pretrial release on a dating violence case. And I do find probable cause for that offense, and I'll appoint the public defender. We do have a witness present. Ma'am, can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, you got to just a little bit closer for me. Thank you. You can put your hand down. Can you state your name and then spell your last name for me, please?
Erica Frazier, Frazier.
All right, Miss Frazier, how do you know Mr. Robinson?
He's my ex. We were in a relationship.
Okay, are you still in that relationship or dating? Okay. Are you living together?
No.
Okay, are you afraid of him?
Yes.
Okay, so my guess is you do not want contact with him, and there's currently a no contact order in place.
Right, which he violated yesterday.
That is what he's charged with.
Right.
Okay, all right. Did you, anything else you wanted to tell me?
No, I'm trying to figure out, because being that he vandalized my home and my children's things, I'm trying to see how can I retrieve my children's things, because they have nothing.
And where are those things?
I don't know, because he waited till we left the house yesterday, and he came and took everything out the house.
So that's gonna be a civil issue.
Okay.
Okay, I can't order him to necessarily give you things
Right.
back, okay?
Right.
Because I don't know where they are or
Right.
anything. That's civil issue. So you have to probably contact an attorney for that.
Okay.
Okay? Ms. Fusco, do you have any other questions for Ms. Frazier? Okay. Ms. Fowler? Or-
No questions, Your Honor.
All right. All right, Mr. Robinson, you're ordered to have no contact. You already have a no contact order in place, so you have to continue to no contact with the victim, directly or indirectly. Do you understand?
Yes, ma'am.
I'm also ordering no contact with any of the witnesses that were present at the time of the offense. Do you understand that?
Yes, ma'am.
Okay. I had you sign the no contact order. Did you understand everything in the form?
I understand everything, Your Honor.
Okay. You must maintain separate residences. You're not to return back to the residence.
Your Honor, can I do that one-time return so I can retrieve my items out of her possession?
You must go with law enforcement.
Yes, ma'am.
One time.
Yes, ma'am. Thank you.
So no weapons or firearms or any ammunition. The bond on the new law violation is $2,500. You're out on release for the DV battery. You violated the no contact order. I am gonna revoke that release. Is it bond and pretrial release, or is it just pretrial? Okay, so I'm revoking the bond and the pretrial release.
No problem.
Does he have the PD?
He does.
Connor Wade, okay, or Wade Connor. All right, you do have the public defender in that case, Mr. Robinson. They're gonna have to file a motion to set bond for you in that case in the trial division, okay?
Yes, ma'am.
All right, good luck. Thank you, ma'am.
Thank you.
I'm sorry, Your Honor, what was the bond in today's case?
2,500. Oh, sorry. Today's the 9th. All right, good morning. Tell me your name, please.
Wyatt Smith.
All right, Mr. Smith, you're here in 2020 MM 4161AO. You're arrested for domestic violence battery. I do find probable cause for that offense, and I'll appoint the public defender. We have no witnesses present in the gallery at all. There's nobody in the gallery, so I am ordering that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order form. Did you understand everything in that form, sir?
Yes, ma'am.
Okay. You're also going to have to maintain a separate residence. You're not to possess or consume any alcohol or any illegal substances without a valid prescription, and no weapons or firearms or any ammunition. Looks like this is your residence, okay? So
Yes,
you just
this
have to
is-
maintain separate residences from the victim, okay? And you do qualify for pretrial release. I'm gonna place you in pretrial release, okay?
What exactly does that mean, Your Honor?
You'll have to report, but you'll be released without a bond.
Oh,
You
thank
won't have to post a bond, okay?
Thank you.
All right, please tell me your name.
Rhonda Pacheco.
All right, Ms. Pacheco, you're here for a no valid driver's license in 2020 CT 474A. And I do find probable cause, and I'll appoint the public defender. Was there an offer today to resolve the case? You're not on probation anywhere, right?
No.
The history of, I think, multiple out-of-state similar offenses, Your Honor, so I would hold an offer today.
Okay, so Ms. Pacheco, if you wanted to resolve your case today, it would be a 5-day offer. I think you have credit for 2 days' time served. Do you want to talk about that?
I have 4 children at home with my 19-year-old daughter has mental disability.
Okay.
And
Okay. Well, then, we won't resolve your case today, okay? So she does not qualify for pretrial because of her outstanding warrant? Oh, she has a hold with no bond? Okay, you have a hold with no
I
bond,
was told
ma'am.
last night that the bond lady sent the letter to them, and I don't know what happened from there to see
Okay,
if
well,
I get a bond.
I don't have that information in front of me. They're just telling me that you have no bond. So I don't know if you want to resolve the case or not, because probably not going anywhere for a couple days.
Can we have a moment to just talk to her against the wall?
Sure. Absolutely. What's the St. Lucie? Failure to appear, okay. That's not the Georgia warrant though, right? Okay.
First grader. That's not.
Go ahead up there.
All right, Ms. Custon, what do we want to do?
Your Honor, my client would like to plead no contest to this case and hopefully figure out something with the other.
Okay, I can't, I don't know all I know is what I'm being told is a failure to appear on the leaving the scene of an accident case in
Right.
St. Lucie. That's all I know, okay? So, Ms. Pacheco, did you read the plea form before you came into the courtroom?
Your Honor, she doesn't read that well. Would you
Okay.
like me to explain it to her, or would you do?
Yeah.
Okay.
That'd be great, thank you. Can Ms. Fowler continue on with the other defendants while that is going on? Okay.
Yes, Your Honor.
Okay.
Your Honor, the next person on the docket, Daly St. Jean, refused.
Okay, so, I've got Mr. St. Jean, I'm gonna appoint the public defender. Ms. Fowler, do you wanna waive?
Yes, Your Honor.
Okay, it's, 2020 CT 3676. It's a driving under the influence with property damage to the person or another. And I do find probable cause. And I did appoint the PD, no drugs or alcohol without a valid prescription, no contact with any victims or witnesses in the case. I'm not gonna take any action on the out on release case. However, the bond will be set at $2,500. All right, tell me your name, please.
Salazar.
All right, Ms. Salazar, you're here in 2020 CT 3678. You're arrested for driving under the influence. I do find probable cause for that offense, and I'll appoint the public defender to represent you. So no drugs or alcohol without a valid prescription. I'm gonna place you in pretrial release. Make sure no drugs or alcohol without a valid prescription. Don't get rearrested or anything like that, okay? Keep in touch with your attorney.
The next person on the docket for the misdemeanor arraignments, Omar Stevens, will not be attending due to behavior.
Okay, I didn't have Mr. Stevens. I had Larry Smith, Devontae Smith. The only person I had on the docket was him.
I don't know about that.
But I know, but Odyssey only shows one arraignment anyway for today. Yeah, we don't have him. Do we have Devontae or Larry Smith?
No, Your Honor.
No. Do we know if is he still in jail? A jail number, the inmate number is 200-10551.
Does he have an alias?
I'm sorry, I can't hear anything, Courtney.
That's what Omar Stevens said.
That's Omar. I think he have an alias, Your Honor.
Oh,
Larry Devon. That's one of his alias names.
okay.
Larry Devon Smith. So Omar Stevens is the same person.
Okay, thank you. All right. And you said behavior?
Yes, Your Honor.
Okay. And it's a battery, so I don't think we would be resolving the case today. Ms. Fowler, do you want to enter plea of not guilty?
Yes, Your Honor.
Okay, we'll give you a date.
Division 63 pretrial conference, July 23rd at 8:30, courtroom 12C.
All right. And then do we have Ms. Pacheco? All right. Ms. Pacheco, were you able to go over that plea form with Ms. Custon?
Yes,
Did she explain everything that you had any questions about?
yes,
Okay, you understood everything on the plea form?
yes,
You understand all those rights you're giving up by entering the plea?
yes, ma'am. Because I
And
will-
you're not on probation anywhere? Is that a yes or is that, you're
I have
shaking your head no?
I'm sorry, I have no probation, no record.
Okay, okay, all right.
That's long time.
You understand that if you're not a US citizen, the plea will subject you to deportation?
I'm legal.
I know, but I have to ask you that question. So you understand that if you're not, that you will be subjected to deportation?
Yes.
Okay. All right, I do find a factual basis to accept your plea. I'll adjudicate you guilty, sentence you to 5 days with credit for 2 days' time served. I'll order that you pay your court costs by June 9th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Will we see her for the other case tomorrow?
No.
No?
It's a hold. He has a
It's just a hold? Okay, all right. All right, thank you, ma'am. All right, and then we have 33-day motions. Are you all ready on those, or do you need a minute?
I'm ready, Your Honor.
Ms. Fowler?
I'm ready, Your Honor.
Okay. All right, I have 2020 CF 5618AO Kimani Ojai Christie.
Yes, Your Honor, on June 8th, there was a notice of non-filing.
All right, that will be granted. 2020 CF 5459AO Agardo Francois.
Yes, Your Honor, on June 8th, an information was filed, filing ID 108542048.
All right, that will be denied.
Your Honor, may I
Yes.
speak?
Hit mute and put the volume all the way
Yeah, I just lost audio, Your Honor.
They told me to put it down. Sure? Can you hear me now?
Vaguely. That's,
No, it,
yeah, I can hear you now.
okay. But we're connected?
We are
Okay.
connected. We can see and hear.
Okay. Is it better than before?
Absolutely.
Let me
Well, I don't
see
know
if
about-
Ms. Fusco, could you just say something?
Can you hear me with the shield on, Dexter?
Yeah, we can hear a lot better. It's just muffled because of the mask, but
Yeah.
There we go.
Well, we'll see if this works. I think we're on the record. I don't know because I didn't call anybody. Let's just call her and make sure. Good? I think we've resolved the issue. Okay. Not sure why I have this on my screen, but you all can see me over there, right?
Yes.
Okay, thank you. Not just the courtroom, but. Yeah. Thank you. Okay. Look, we're on the record. What she's saying. Okay. All right, this is Judge Wish. It is PRC Courtroom 1, videoing to Courtroom 2, and it is second session on June 9th, 2020. Can I have the parties announce themselves for the record, please?
Ilana Fusco, State Attorney's Office.
Good morning, Zara Manikia for the Office of the Public Defender.
Bradford Fisher for Mr. Malloy.
Okay, Mr. Fisher. Did you file a notice of appearance, or are you intending to do so today, or?
I think we've already filed it.
Okay.
I know I filed it on the new law charge. I think we've already filed it as to this one, but if not, it's going to get filed. He just got arrested on. Yeah, we filed it.
Okay, and Mr. Malloy is up first. I'm getting used to the second screen.
Okay, yeah, write it down. Okay. If I feel comfortable, I'll walk over and give it to them too. I'll see how it goes because I've never been.
who we want to start with, Your Honor? The private attorney? or-
Mr. Malloy, yeah, Mr. Malloy.
Okay, one
Thank
second.
you. Okay. Well, hopefully this is better for, we had a lot of technological issues.
Believe it or not, they've done a pretty good job in Orange
Yeah.
County.
We
So
have
I've actually been really impressed.
just little kinks.
Okay, I'm thrilled if I can get, a new contact in my cell phone. I don't think that I could really complain about what they do here.
Good afternoon. Can you tell me your name, please?
Good afternoon, Your Honor. My name is James Malloy.
All right, Mr. Malloy, I have Mr. Bradford Fisher over here with me. He's representing you through, are you the attorney of record or?
For Umansky, yes.
Okay. All right, and so this is 2009 CF 12432AO.
And this is a violation of probation, Your Honor.
Hold on. Let me just get through it. So it's a VOP, and I'm not going to appoint the PD because you do have an attorney, Mr. Malloy. And Judge Harris did set your bond, I believe, at none. Mr. Fisher, are you arguing for a bond?
I am asking for a bond, yes. I'm not so much arguing because we don't have a right to one as a matter of right. However, this is a DUI. Mr. Malloy is an alcoholic, and he got a DUI, I guess, after being out on probation for about a year. Because I represented him in an earlier motion with Judge Harris that was granted. I'm not arguing that there isn't a violation of probation. We're not arguing there's not a new law charge. But to be blunt, this criminal case for which he's got a violation has gone on for 11 years. I actually want the court to set it for a plea date, if you can do that on
Can't
somebody
do
else's
that.
calendar.
Yeah, I can't do that. So what?
But in terms of a bond, he lives here. He's works for a timeshare agency. He's he is their top salesman, actually. He's got a job. He lives with his parents who are about 80. And apparently he has a series of medical concerns that they're now raising. He's got a huge blood pressure. They're trying to bring under control. They're worried about him having COVID, although they've tested him and he came out negative. And he's got medical concerns.
All right.
So we're worried about him being in custody. I'd ask the court to give him a bond. And if we can set a plea date, great. And if we can't, if you could tell me which judge has it, I will then set a plea in front of them.
Division 12, and I believe that is now Judge Calderon.
That's what I thought.
Right. Judge Harris went down to juvenile. So I'm not going to disturb Judge Harris's bond, and Judge Calderon will accept any motions to set bond. They're getting them heard very quickly downtown. So, and I'm showing he has an open traffic case as well. He's out
That's
on
the
release.
DUI, and that's
Okay.
we're already in the process of setting that for a plea.
All right. So I'm not going to disturb the warrant, Mr. Fisher. I understand I have discretion to do so, but I'm just not going to do that today. And so, Mr. Malloy, Mr. Fisher's a great attorney. He's going to file a motion in front of Judge Calderon. You will be set in front of Judge Whitehead in a couple days for the arraignment. You may be able to resolve everything on that day as well. Do we know that date, Denise?
Yes.
I can give you that date, Mr. Fisher.
What date is that?
June 11th at 9:30.
So that's 2 days from now. And he'll, I believe, Judge Whitehead is downtown.
The only problem with
videoing.
that is that I actually have an injunction hearing at the exact same time.
Well, they may be able to set it later on in the day or earlier, but you can talk to Judge Whitehead. Ms. Becton is his JA. You might be able to get it set, but I think he only does it once a week. Does the arraignments, but you could file a written plea of not guilty and just deal with it.
Well, I'm trying to get a plea set anyway.
I understand. So you'll have
Thank
to
you,
do
Your
that
Honor.
with Judge Calderon, okay? All right, Mr. Malloy, thank you so much. Have
Thank
a
you,
good
Your Honor.
day. All right. All right, good afternoon. Tell me your name, ma'am.
My name is Shamira Jackson.
All right, Ms. Jackson, you're here in 2020 MM 4164AO. It's an open container violation, and I do find probable cause. I'll appoint the public defender. Ms. Fusco, did you have an offer for Ms. Jackson?
Yes, Your Honor, adjudication of guilt, credit for time served, court costs.
Is it 2 days or 1 day? Do we know?
It's 2 days.
Okay. So, Ms. Jackson, if you want to resolve your case today, it would be an adjudication of guilt, 2 days in the Orange County Jail, 2 days you've already served, so it's credit for time served. And I won't take any action on the out on release case. You do have a court date, you just can't miss that court date, okay?
Okay, thank you.
You want to do that?
Yes, please.
Okay. Did you read the plea form before you came in the courtroom?
Yes, I did.
Did you understand everything contained in that plea form?
Yes,
You understand all those rights you're giving up by entering the plea?
yes.
Are you on probation anywhere?
No, I'm not.
Okay. You understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, I understand.
Okay. I do find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served. Order you pay your court costs by June 9th, 2021. That gives you a year. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you, ma'am. Good luck.
Thank you.
So I'm wondering when Amy comes in, because it says 777. It doesn't say, we'll have to call JR and just make sure.
Yeah, and I'll be here tomorrow. I'll come
Okay.
in before court starts.
Good afternoon, sir. Tell me your name, please.
Kevin Jones.
All right, Mr. Jones, you're here in 2020 MM 4155AO. It's a possession of cannabis less than 20 grams. And I do find probable cause. And I'll appoint the public defender to represent you. And is he being held on a probation or
Yes, Your
parole?
Honor.
Okay. So as it relates to this case, you're on probation, so we would not resolve it today. The state's really not prosecuting cannabis cases. So what I'm going to do is, Mr. Jones, I'm going to ROR you on this case. You'll just have to deal with the violation and whatever you're being held on in the other case.
Can I
Okay.
say something? Can I say something?
I don't want you to talk about the facts of anything.
No
Okay.
problem. In
Okay.
Virginia, you don't get violated for a crime until you get found guilty. That hold that they're seeing is the warrantless VOP that was issued from Florida. Virginia hasn't responded. So I had this issue before, but Virginia hasn't responded. So I'm just on hold, waiting for Virginia to respond for something that they're. But if I'm getting RR'd on marijuana, there's no need for the thing. Is all I'm saying.
Well, hold on, let me see if they can tell me what may or may not be going on in Virginia, okay?
Oh, I'm
I don't
sorry.
have any information.
Do we know anything?
We will have to follow up with DOC to see what DOC wants to do. I don't have any information at this
Okay,
time.
they don't have any updates. The public defender was appointed in this case, so I urge you to call them and find out about, and maybe the hold will get released in the interim. I
Okay.
don't know, but I can't release that hold from Virginia, okay?
Yes, ma'am.
So we'll see what happens.
I was just confused. I wasn't sure if Virginia put the hold or Florida put the hold until they heard back from Virginia. So I was a little confused.
Was he being held on that other case?
It's an on view.
It's an on view, but I don't have it.
He's not gonna come to court because it's like parole. They have
Okay.
a separate hearing.
So will Virginia, has there been any communication with Virginia?
I will have to follow up when I go
Okay,
downstairs.
okay. So they're gonna follow up with Virginia. Should we set him on the docket, just in a?
It's something that's not heard in IA, so.
I know, but, okay, all right. I can't reset the hold because it's not a case that's in front of me.
Mhm.
But the public defender is there. I'm gonna have them give you a piece of paper, call that phone number, okay?
Okay. So basically, lastly, I'm ROR'd and I'm just waiting until this hold is completed. Yes, ma'am. Okay. Thank you.
We'll see. They're gonna communicate with Virginia, okay, sir?
Thank you. Perfect. Thank you.
All right, good afternoon. Tell me your name, please.
Jermaine Murray.
All right, Mr. Murray, you're here in 2020 MM 4173. It's trespass in an occupied structure or conveyance, and I do find probable cause. And I'll appoint the public defender. Ms. Fusco, did you have an offer?
Yes, Your Honor. Adjudication of guilt, 3 days with credit time served, court costs, no return to the scene of the trespass at the airport at 1 Jeff Dukewood Boulevard.
All right, so Mr. Murray, you're off. The state's willing to resolve your case today if you want to do that. It's 3 days with credit for 2, I believe. Is that correct? You have 2 days in?
Yes, Your Honor.
Okay, so that would get you out, I think, by the end of the day.
Sure.
By 11:59, I think, that they would get you out.
Okay.
And no return back and abide by the trespass warning. If you want to do that today, you won't have to come back to court for this case.
Correct.
You want to do that?
Yes. I'm sorry.
Okay. So I'm not going to revoke your release on the other case. Just keep reporting to pretrial release.
Sure.
And you have a court date coming up in July.
I know it's like, would you happen to have the date? I can always check.
I think it's July 9th at 9:30 a.m., I believe.
Yeah, I think that's right.
Okay, I think so. Yeah, we'll check it when we're done. Did you read the plea form before you came in the courtroom?
Yes.
All right, and did you understand everything that was contained on the plea form?
Yes.
And are you on probation anywhere?
No.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes.
Okay. I do find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 3 days with credit for 2 days' time served. You may not return back to that Orlando International Airport, 1 Jeff Dukewood Boulevard, and abide by the trespass. Okay, if you go back, you'll probably get arrested again. And I'll order you pay your court costs by June 9th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. And we'll get that. We'll make sure we have the right court date for you.
July 9th at 9:30, courtroom 9B.
9B.
9B. Okay.
Make sure you get in touch with your attorneys ahead of time because you may or may not have to be there in person. I don't know how they're doing the arraignments just yet. They're trying to figure that all out, okay?
Okay.
Okay?
This is a lot better. Thank you.
All right, good afternoon. Tell me your name, please.
Cortez Anderson.
Okay, do we know what happened to Jasmine Ambert? She bonded? Okay. All right, well, we'll take no action on that case. Okay, Mr. Anderson?
Yes, ma'am.
Okay, you're here in 2019 CF 120780, and it's a failure to appear. Looks like for a pretrial conference on September 10th, 2019, and the judge did revoke your release on the case. Does he have the public defender? Okay, you do have the public defender's office, so you're gonna have to get in touch with them to file a motion to set bond in Division 17, okay?
Ma'am, excuse me, ma'am.
Yes.
I can speak at the podium, ma'am.
Your Honor, I would advise him to not speak about the facts of his case.
I would like to speak to you about the reason I was put FTA on, ma'am, please, if you don't mind.
Well, you can tell me whatever you want. I just want you to know you're being recorded, so anything you say
Yes,
can
ma'am.
be used against you. And I can't change the capias. I'm not permitted to by law. Your attorneys would have to ask the judge who signed that capias to change it.
So,
So I don't know. Whatever you want to tell me may not be to your benefit because I can't do anything today. I'm not allowed to under the law, sir. So I have to follow the law.
how long will it be until I see my original judge downtown?
Well, I don't know because you'll be set for new trial dates. But who's in there right now? Is that Miss Fowler?
Miss Manikia.
Oh, Miss Manikia, how are you?
Good, how are you?
Good, thank you. So will you, do you know how long it will take them to get a bond motion in there?
I'll request one today to his attorney.
Okay? All right, sir. So she's going to request your attorney file a bond motion. Okay? That's all we can do for you today.
All right.
All right, good afternoon. Tell me your name, please.
My name Lockett Andrews, Jr.
All right, Mr. Andrews, you're here in 2020 CF 311180, and you were arrested pursuant to a warrant in which probable cause was found for failing to register upon release as a sexual offender. And I believe you do have an attorney already in the case.
Yes,
And they already have filed a notice of appearance, and an information was already filed in the case as well. So I believe your attorney, you have a private attorney?
Yes, Patricia Montgomery.
Yes, okay. So you're gonna have to get in touch with her. I am not gonna revoke the release on the other case today, okay?
Yes.
But I am gonna set your bond at $3,500. So if you can't make that bond, you're gonna have to have your attorney file a motion to reduce the bond amount. You also do have reporting requirements. I know that your attorneys have filed some motions about whether or not you really had to report.
Yes.
But that was actually denied without prejudice for them to file another motion with Judge Beamer. But I would comply with any reporting requirements that you've been ordered to comply with, okay?
But could I say something?
Well, I don't want you to talk about the facts of your case
No, but.
or or the other case too.
But I went yesterday and I already registered.
Okay, well, that's good. But this has to do with when you were released from the jail before and did
Yeah.
not register. Okay, so you need to talk about it with your attorney, okay?
So even though I registered yesterday and I
Has
still
nothing
was
to do with-
arrested, I
yeah.
can't be let out on the RR? Already?
No, I'm not gonna ROR you, sir, but you have a bond, okay?
And what the bond is?
$3,500.
All righty.
All right, please tell me your name.
Earl Maurice Denmark?
Okay, do we know what happened to Benjamin Contreras?
No, ma'am.
He's behaving, Your Honor.
Okay. Mr. Contreras' behavior, I'm gonna find that to be a waiver. Appoint the public defender. Ms. Manikia, do you wanna waive his appearance?
Yes, Your Honor.
Okay, he's charged with burglary of a structure, criminal mischief, and petty theft. and I do find probable cause. And so no return to where the offense is alleged to have occurred, no contact with any victims or witnesses. And I'll do bond or pretrial release. I'll stay the bonds at $3,500, $100, or pretrial release if he qualifies, but he has not been interviewed yet, so he would have to be interviewed. All right, Mr. Denmark,
Yes, ma'am.
you're here in 2020 CF 296780. You were arrested pursuant to a warrant, and probable cause was found for possession of a controlled substance and possession of drug paraphernalia. And I'll appoint the public defender to represent you in your case. And so no drugs or alcohol without a valid prescription. I'm going to release you on your own recognizance. So within 24 hours, I want you to get in touch with the public defender's office, okay?
Yes, ma'am.
Make sure they know how to get in touch with you so that you don't miss any upcoming court dates should you need to go to court.
Yes,
No
ma'am.
drugs or alcohol without a valid prescription, okay?
Yes, ma'am. Yes, ma'am. Okay. Thank you.
All right, good afternoon. Tell me your name, please.
Mariana Desroches.
All right, Ms. Desroches, you're here in 2020 CF 7098AO. You were arrested pursuant to a warrant. Probable cause was found for aggravated battery with a weapon, introducing contraband into a county detention facility. It looks like that was corrected on the warrant. They originally had a violation of probation, but it was corrected. And throwing a deadly missile at an occupied vehicle and battery. And so I will appoint the public defender's office to represent you. No contact with any victim, any witness, or any co-defendant, no weapons, no firearms, and no ammunition, and no return back to where the offense is alleged to have occurred. Count 1, your bond is $15,000. Count 2 is $2,500. Count 3 is $2,500, and count 4 will be $100. I'm not going to revoke your release today. You do have an upcoming court date. You do not want to miss court, okay? Good afternoon. Tell me your name, please.
My name is Ronaldo East Senior.
All right, Mr. East, you're here in 2020 CF 7121AO. Possession of a firearm by convicted felon and open carrying of a weapon or a firearm. And I do find probable cause. I don't have a form for the public defender. Were you planning on hiring your own attorney?
Yes, ma'am.
You are? Okay. You currently have a bond at $4,100. Are you going to be able to bond out
Probably so. Yes.
soon? Okay.
Yes.
All right. So no weapons or firearms or any ammunition. I am going to stay the bond at the $4,000 and the $100. I'm not appointing the PD. Do you want me to, in case you're not able to bond out, do you want me to set you for a status hearing in a week for a determination of counsel, just in case you're not able to bond out? Or do you are you pretty sure you're going to be able to bond out?
I'm not sure of how fast I'll be running out, but
Okay. So we'll set him, can we set him for a DOC in the week? And if you're not able to bond out, we'll address the attorney issue, okay?
yes, ma'am.
All right. Good afternoon. Tell me your name, please.
Robert Aaron Geib.
All right, Mr. Geib, you're here in 2020 CF 7109AO. It's attempted robbery. I do find probable cause, and I don't have a form for the public defender. Are you planning on hiring your own attorney?
Ma'am?
I don't have, did you fill out a form for the public defender?
I was I'm gonna try to get my own attorney.
Okay.
The bond amount is I was hoping that I could be maybe released, seeing that my bond is. I was hoping I could be maybe released on my own recognizance.
Does he not qualify for pretrial release?
He does not. It's the typo on the thing.
But I don't.
Can I order him into pretrial release?
It's a type of offense per the admin order.
It's what?
The type of offense per the admin order.
It's an attempt.
It's still classified as large.
Where are you living?
I live in Castleberry,
What is the address?
604 Fellowship Drive.
In Castleberry?
Yes, ma'am.
Who do you live there with?
I live there by myself at the moment. My parents own the place, and I'm the only one that's allowed to live there. I'm the only one that's currently staying there on the lease. And
All right, Mr. Guy, I'm gonna release you on your own recognizance. Listen to me very carefully. You cannot miss court.
yes,
No weapons, no firearms, no ammunition. You may not go back to the 7-Eleven at 999 East Colonial Drive, nor may you have any contact with any victim or witness at that location. Do you understand?
yes, ma'am.
Okay. I'm gonna order that you get in, I'm gonna appoint the PD for you, okay? If you wanna hire an attorney, you can do that. But I am gonna appoint the PD, and I'm gonna ask that you get in touch with them within 24 hours of your release from the jail so that they are able to get in touch with you should you need to go to court, okay?
Yes, ma'am.
Good afternoon, tell me your name.
Jeffrey Hamilton.
All right, Mr. Hamilton, you're here in 2020 CF 7126AO, and you're arrested for grand theft third degree of a motor vehicle and possession of cocaine. I do find probable cause for those offenses, and in 2020 CT 3692AO, driving the license suspended as a subsequent offender, and I find probable cause, and I'll appoint the PD in both the cases for you. No driving without a valid driver's license, no drugs or alcohol without a valid prescription, and no contact with any victims or witnesses. You do qualify for pretrial release. I'm going to place you in pretrial release, okay?
Pre-trial release, ma'am?
Yes.
Thank you.
All right, good afternoon. Tell me your name, please.
David Edward Harris.
All right, Mr. Harris, you're here in 2009 CF 7536AO, and that's pursuant to a warrant. Looks like, or Capias, the state did file an information charging you with dealing in stolen property as trafficking, receiving money from a pawnbroker by false verification of ownership or identification, and petty theft of $100 or more. And so probable cause was previously found by a judge in the case. And in that case, you're not to return back to the victim's residence or to Mike's pawn shop as listed in the app or in the discovery documents in the clerk system. And the bonds will stay set on count 1 at $7,500. Count 2, I'll reduce to $150. Count 3 will be $100. No contact with any victims or witnesses as well. And then they did file back during, I believe, that time period, they did file a violation of probation warrant in 2018 CT 1328E. And so that bond is set at none. And I'll appoint, well, I did appoint PD in that case for you. So they're gonna have to file a bond motion for you in that case. Ms. Manikia, do you wanna do the arraignment and then get him on the docket?
Yes, Your Honor.
Okay. So, Mr. Harris, you're alleged to have violated your probation by not making a full and truthful written report to the probation officer for the months of September 2008 through February 2009. You did not maintain full-time employment at a lawful occupation or maintain a full-time student status as ordered by the court. You did not comply with instructions given by your probation officer when you failed to keep intake appointments on December 17th of 2008 and January 5th, 2009. You failed to pay $40 a month cost of supervision for the months of November 2008 through February 2009, currently at 160 in arrears. Failing to enroll in the DUI counterattack class by December 18th, 2008 as ordered by the court. Failing to enroll in the Victim Awareness Program by 12/18/2008 as ordered by the court, and failing to attend and complete the Victims Awareness Program by February 16th, 2009 as ordered by the court. So we're going to enter a denial on your behalf and get you on the docket as soon as possible for the violation.
Okay.
In the meantime, your public defenders can file a motion to set bond for you, okay?
Yes, ma'am.
Division 83, VOP status, July 13th at 1:30. Courtroom 6B.
Does this mean I'm released or something?
Okay, thank you, sir. All right, good afternoon. Tell me your name, please.
My name Darren L. Mayweather, ma'am.
What is it again? I'm sorry.
Darren Lewis Mayweather.
Okay. Do we know what happened to David Harvey?
He refused, Your Honor.
He refused?
Yes, Your Honor.
Okay. So Mr. Harvey refused to come to court. I'm going to find that to be a waiver and appoint the public defender. Ms. Manikia, do you want to waive?
Yes, Your Honor.
All right. So Mr. Harvey's charged in 2020 CF 7115AO with possession of fentanyl, possession of drug paraphernalia, and possession of heroin. And I do find probable cause. The bonds will stay at $1,000, $100, and $150. No drugs or alcohol without a valid prescription. I'm not taking any action on the out on release case. He does have an attorney in that case. All right, Mr. Mayweather,
Yeah, ma'am.
you're here in 2020 CF 7119AO. You're arrested for possession of a firearm by convicted felon, and I do find probable cause. I'll appoint the public defender to represent you. No weapons or firearms or any ammunition. The bond will stay at $4,000. I'm showing that on your out on release case, the state actually filed a no information notice today. So that case is over, in case you didn't know that.
Okay.
But you are on probation, so I'm not sure if your probation officer will file a violation of probation, so you could be subject to getting arrested on a warrant if you get released from jail, just to let you know, okay?
Okay.
All right. All right, good afternoon. Tell me your name.
Kevin, man.
All right, Mr. Mann, you're here in 2020 CF 7125AO. You're arrested for attempted burglary of a conveyance. I do find probable cause, and I'll appoint the public defender to represent you. No return back to where the offense is alleged to have occurred. No contact with any victims or witnesses. I am going to set your bond at $3,500. You're out on release for very similar offenses in 3 cases. And so I'm not going to revoke that release, but I did increase the bond in the case, okay? Thank you.
Okay.
Good afternoon. Tell me your name.
Hello, ma'am. Claude Junior Rue.
Okay. Do we know what happened to Anthony Marcus?
Ma'am, Yeah.
Booking number.
This is Anthony Marcus, Your Honor.
this is
Oh.
last time I was here, ma'am. They told me to say the name I was booked under, but that's the wrong name. It's another confusion, I guess. But
Okay. Well, I don't know. They booked you under Anthony Marcus. Okay. So you're here as an add-on. It's 2020 CF 7103AO. You're charged with 7 counts of burglary of a conveyance. And I do find probable cause for those offenses. And I'll appoint the public defender to represent you in the case. So no return to any location is named in the affidavit. No contact with any victim, witness, or co-defendant. There's been a number of bond corrections for counts 2 through 7. There should have been a bond correction for count 1 as well. So count 1, setting at $3,500. Counts 2 through 7 are $150. All right, thank you, Mr. Marcus, or Mr. Claude. All right, good afternoon. Tell me your name.
Robert Devon.
Okay, do we know what happened to Charles Blanchard? Okay, thank you. We will take no action on those cases. And you said Devon?
Devon.
Okay. All right, Mr. Devon, you're here in 2018 CF 6941AO. You were arrested pursuant to a warrant for a violation of probation, and the judge did set your bond at none. And so I will appoint the public defender. You'll see Judge Whitehead in a couple days for your arraignment, and the public defender can also file any motions to set bond for you. Okay?
Thank you.
All right, good afternoon. Tell me your name.
Pierre DeHady.
All right, Mr. DeHady, you're here in 2018 CF 17099. You were arrested pursuant. Well, is this just the bondsman came off the bond?
He has a VOP and an endorsement.
Okay, so they filed an on-view VOP based on the new law arrest on June 7th. So there is probable cause for the VOP, and I'll appoint the public defender to represent you in that case. You'll see Judge Whitehead in a couple days for your arraignment. Does he need to be IA'd on the other case?
Yes, Your Honor.
Okay. So it looks like the bondsman came off your bond on the burglary of an unoccupied conveyance. And so I don't have a case. Oh, 2020 CF 7070. And you're charged with burglary of an unoccupied conveyance. And there's probable cause. I'll appoint the public defender in that case as well for you. The bond is $3,500. No return back to the scene, no contact with any victims or witnesses.
He also has an immigration hold.
And there's an immigration hold. Okay, so yeah, I do see that now. Thank you, Courtney. You do have an immigration detainer, Mr. DeHady, so the public defender's office will be able to help you with that, okay? But I can't remove that detainer. All right, good afternoon. Tell me your name, please.
Charles Ware.
Mr. Ware, you're here in 2018 CF 14096. It's an on-view violation of drug offender probation. And there's probable cause for that. There's also an on-view VOP for drug offender probation in 18 CF 12291. And I find probable cause. And I'll appoint the PD in both of those cases. You'll see Judge Whitehead in a couple days for your arraignments. Those bonds will stay at none. You've got 2020 CF 69290, and that's a warrant. Probable cause was found for possession of MDMA and possession of drug paraphernalia. And I'll appoint the public defender in that case to represent you. No drugs or alcohol without a valid prescription. I don't know why the bond is $5,000. It's not within 10. So, I'm gonna reduce that bond to 1,000 and count 2 to 100. And then 2020 CF 7123AO, possession of MDMA, and I do find probable cause. I don't know why the bond came in at 5,000 either on that one. No drugs or alcohol without a valid prescription. I'll set the bond at 1,000. And so the public defender will have to file any motions to set bond for you in the other cases. Okay?
Yes, Your Honor.
Good luck, sir. All right, good afternoon. Tell me your name.
Mello Alexander.
All right, Mr. Alexander, you were picked up on a Seminole County warrant, and the judge in Seminole did set your bond at none. And so what I'm going to do is here appoint the public defender to represent you here. And I think one of the judges here is going to reach out to Seminole County to see if they can get you a bond. So you'll probably be on our docket in a couple days, okay?
All right.
All right, good afternoon. Tell me your name.
Brandy Powers.
All right, Ms. Powers, you were picked up on a Brevard County warrant, and the judge in Brevard did set the bond at none. And so, they're not transporting people right now. I'm going to appoint the public defender here. They'll reach out to the judge in Brevard County, see if they'll be able to give you a bond. So we'll put you back on the docket in a couple days for a status hearing as to a bond, okay?
Okay.
All right, anything further? All right,
No, Your
hearing nothing? Okay, I got a head shake. Anything else from anyone? No?
No, Your Honor.
Okay, we will be in recess for the day. Thank you.
Thank you for your help. Thank you.
Patience.
Oh, yes, you can have all of them back. So when it's a private attorney, I don't fill out a bond motion? And what if it's PTR ROR? Do I put that on the bond motion? If it's represented by the PD's office?
If it's represented, yeah, you can put it.
Yeah, okay. And is there anything else I need to know to put on those forms?
Annabelle Soriano. I believe it's probably Ms. Smith's case. Come on up, sir. State your name, please.
Aníbal Soriano.
Mr. Soriano, you were here today for arraignment on an amended information in case 17 CF 3348. You are charged in this case with lewd or lascivious molestation. Count. Did you wish to waive the?
Yes, Your Honor, waive the reading of the information.
Enter
Enter a plea of not guilty.
I'll accept the plea of not guilty as to the amended information. Ms. Smith is stepping in. Okay, that's fine.
Oh, he needs the interpreter, Your Honor. I'll let Ms. Smith take over.
Okay.
morning. This is the Spanish interpreter.
All right, and have you been sworn this morning?
No, I have not.
You solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability?
Yes, Laura Royo, state certified interpreter. Can you give me a second, Your Honor, to connect to the podium, please? Connection is established.
Okay. All right, we're here in case 17 CF 3348, State versus Anibal Soriano. Mr. Soriano, if you'll state your name again, please.
Aníbal Soriano.
Annabelle Soriano.
And Ms. Smith, before we had got the interpreter online, Ms. Hernandez, standing in for you, had waived the reading of the amended information and entered a plea of not guilty. Is that what you wish to do?
Yes, Judge.
Okay. So we'll accept the plea of not guilty to the amended information in case 17 CF 3348. This case is set for jury trial on July 27th, and it should be ready to go at that time. Is that correct?
Yes, Judge. Are we still doing the July pretrial? I know some of my cases look like they got set off of July, so wasn't sure if this still stayed on or. A lot of my Julys got moved to August pretrial, so I wasn't sure.
This was one we already did the pretrial on.
Yeah. Sorry, yes.
It's not set for a trial period beginning July 27th. It's actually set for trial.
Okay. Then we're good, Judge.
So as far as I know, that's still.
Okay.
I'll have to look. I don't, is this a case in which there's an outstanding child hearsay? Right.
I'm sorry, I cannot hear counsel. She's not near a microphone.
Sorry, council also has a mask on, so.
Right, that's what I was asking. Is it, we're waiting an order on the child hearsay? Well,
It's been a long time.
it has. I'll double check. Okay. Well, we'll have one before trial, obviously. But, okay. So, Mr. Soriano, this case remains set for trial on July 27th. You just need to keep in close contact with your attorney, Ms. Smith.
Muy bien.
Very well.
Thank you. Thank you, Madam Interpreter.
You're welcome. The interpreter will disconnect.
All right, Jorge Vigoa. All right, good morning. State your name, sir.
Jorge Luis Vigoa.
Mr. Vigoa, you were placed on probation for possession of cannabis with intent to sell or deliver, grand theft of $10,000 or more, and cultivation of cannabis in case 12 CF 2023. Do you understand, sir? You understand what you were placed on probation for?
Yes.
You've been accused of violating your probation. It is alleged that you violated probation by failing to pay the restitution as ordered. Do you understand?
Yes.
All right, if you'll raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you shall enter in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
State your name again, sir.
Jorge Vigoa.
Mr. Vigoa, did you fill out and sign this application for criminal indigent status?
Yes.
Is the information that you wrote on this affidavit the truth?
Yes.
Very well, I find that you are indigent. I will appoint the office of the public defender to represent you in case 12 CF 2023. Ms. Hernandez,
Your Honor, enter a denial.
accept the denial of the violation, set the case for a violation probation hearing on August 20th. Status hearing will be August 18th. Thank you, sir.
Yes, thank you.
Talk to your attorney about that.
Not right now.
It is a financial violation, so if he is able to get current, then that would result in dismissal. Okay, Loreniska Belzer.
Your Honor, he's in custody. Mr. Lorenzo.
Okay. Loreniska Belzer, can you all hear us at that end?
Yes, Your Honor, I'm sorry about that.
That's all right.
He's a high-risk inmate. We don't really have room right up here right now.
Okay,
If we can leave him till last.
absolutely, no problem.
Thank you, sir.
Your Honor,
Yes.
actually, since I represent Mr. Belzer, and to help everybody, I'm going to enter a waiver of his appearance and enter a plea of not guilty on his behalf.
All right, so we won't need Mr. Belzer, thank you.
Thank you, sir.
We'll accept the plea of not guilty. The case be set for the August 24th trial docket, pretrial August 12th.
Thank you, Your Honor.
Thank you. Ms. Camaro, you ready on Mr. Rosado Lorenzo?
Yeah, he's, Judge King came out on behalf of Wilkins, Rosado, Lorenzo. We do have a negotiated plea. There's just one issue I'm gonna have to talk to Mr. Rosado Lorenzo about before we do it. Unfortunately, I'm in one location, he's in another location.
That's not a
So
problem.
the state does have a problem to reset this. I don't know
We
what,
have plenty of time this week or next. I don't know when we had the jail feed this week. We could do it this afternoon if,
yeah, I can go to the jail to see him and we can possibly do it this afternoon if the state can. It's gonna be a DOC sentence anyhow, so
Okay,
you want to
so no
reset
hurry.
it for next week or.
all right, I'll reset it for June 15th at 8:30. And if that doesn't work, you can get with Ms. Keene and schedule a different time.
June 15th at 8:30 is good if it's good with the state.
So, Mr. Rosado Lorenzo, Mr. Camaro will be talking to you, and we will, if the case is going to be resolved, we'll go ahead and take care of it next Monday, all right? Thank you, sir. All right, William Figueroa Flores. All right, morning, Mr. Figueroa Flores. If you'll raise your right hand, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name, sir.
William Figueroa Flores.
All right, Mr. Figueroa Flores, you are here this morning in two cases. In case 19 CF 3758, Ms. Cronk has provided the court with a plea form that indicates that you wish to enter pleas of guilty to possession of a controlled substance as charged in count 1, introduction of contraband into a county detention facility as charged in count 2, and possession of drug paraphernalia as charged in count 3. Is that what you want to do?
Yes, sir.
Counts 1 and 2 are both third-degree felonies, which are punishable by up to 5 years state prison, up to 5 years probation, and/or fines of up to $5,000. Count 1 also carries a mandatory 6-month driver's license suspension upon the entry of an adjudication of guilt. And count 3 is a misdemeanor, which is punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand, sir?
Yes, sir.
Okay. Ms. Cronk has also submitted a written plea form in case 20 CF 99, which indicates you wish to enter pleas of guilty to resisting an officer with violence as charged in count 1, battery on a law enforcement officer as charged in count 2, possession of heroin as charged in count 3, and possession of drug paraphernalia is charged in count 6. Is that what you wish to do in that case?
Yes, sir.
And Mr. Kazera, you'll be now processing counts 4 and 5 in case 20 CF 99?
That's correct.
Okay. Mr. Figueroa Flores, counts 1, 2, and 3 are all third-degree felonies, each punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Count 3 also carries a mandatory 6-month driver's license suspension. And count 6 is a misdemeanor punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand, sir?
Yes, sir.
All right. Did you read and fully understand the written plea forms?
Yes.
Okay, now I've got plea forms here that do not have your initials or signature, but did you get a chance to read these plea forms at the jail?
Yes.
I'm sorry?
Yes, sir.
Okay. And did you understand everything on the written plea forms?
Yes, sir.
Do you have any questions at all about anything on the written plea forms?
No, sir.
Are you presently under the influence of medication or any type of drug or alcohol?
No, sir.
Are you thinking clearly this morning?
Yes, sir.
Did any person coerce or in any way force you to enter these pleas?
No, sir.
The recommendation in these cases is that you would be adjudicated guilty of all counts to which you are pleading. You'd be sentenced to the lowest permissible sentence under the Criminal Punishment Code, which would be 22.05 months in the Department of Corrections. That would be as to all felony counts running concurrent. The two misdemeanor counts, you'd be sentenced to time served. You'd be required to pay fine, court costs, public defender lien, and application fee, and your driving privileges would be suspended for 6 months on the possession charges. Is that your understanding of the agreement?
Yes, sir.
You've been represented by Ms. Cronk in these cases. Are you fully satisfied with her representation of you?
Yes, sir.
You believe it is in your best interest to enter these pleas?
Yes, sir.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes, sir.
If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence the court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir.
All right, you do have the right in each of these two cases to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial, you're entitled to a separate trial in each case, and at each of your trials, you would be presumed to be innocent. You could not be found guilty of any crime unless the state proves your guilt through admissible evidence beyond a reasonable doubt. Do you understand?
Yes, sir.
You would have the right throughout your trials to be represented by Ms. Cronk, and you would have the right to confront and cross-examine any witnesses the state might call to testify against you. You also have the right to present witnesses and evidence in your defense. You are entitled to use of the court's subpoena power to require any witnesses you had to be present at your trials so you can present their testimony to the jury. You also would have the right at each trial to testify yourself, or you could choose not to testify at trial. And if you chose not to testify, you have the right to have the jury's instructed they could not consider the fact that you elected not to testify as evidence of guilt. You understand that you have those rights.
Yes, sir.
By entering pleas of guilty, you're giving up the rights we've talked about, as well as the other rights that are written on the plea forms, and there will not be a trial in either of your cases. You also, by entering these pleas, are waiving your right to appeal any matters relating to your cases, with the exception of this court's jurisdiction to hear the cases and the legality of any sentence the court might impose. Do you understand?
Yes.
All right. All right, well, I've read the booking reports or arrest affidavits by Deputy Irizarry in case 19 CF 3758 and by Deputy Perkins in case 20 CF 99. And I do find a factual basis exists upon which your pleas can be accepted based on the affidavits. I would say Mr. Perkins, or Deputy Perkins, was very concise, I guess to say the least. I find that you are alert and intelligent. I find that you understand the nature of the charges against you. You understand the penalties that you're facing in these cases, and you understand the rights that you're giving up by entering these pleas. I find that your decision to enter the pleas has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've said you were satisfied. So I'll accept your pleas of guilty. Ms. Cronk, does the defense have any objection to the score sheet of 57.4 points? Is there anything further to be said before sentence is imposed? What's the time served in these cases?
And 19 CF 3758, 183 days. And 20 CF 99, 149 days.
Okay. All right. Mr. Figueroa Flores, in case 19 CF 3758, you will be adjudged guilty of possession of a controlled substance as charged in count 1, introduction of contraband into a county detention facility is charged in count 2, and possession of drug paraphernalia is charged in count 3. As to counts 1 and 2, you'll be sentenced to 22.05 months in the Florida Department of Corrections with credit for 183 days that you've already served. As to count 3, you'll be sentenced to 183 days in the Osceola County Jail with credit for 183 days time served. Sentences as to counts 1 and 2 will run concurrent with each other. You are ordered to pay court costs of $415, cost of prosecution of $100, court cost for the misdemeanor drug offense in the amount of $15, a fine of $250, $100 public defender lien, and $50 public defender application fee. The money that is owed is ordered to be paid at the rate of no less than $50 every month. You'll have until March 1st of 2022 to make your first payment. Your driving privileges are ordered suspended for a period of 6 months as to count 1. The court has no objection to you obtaining a business purposes license or other restricted driving privilege if you qualify. In case 20 CF 99, you are judged guilty of resisting an officer with violence. It's charged in count 1, battery on a law enforcement officer is charged in count 2, possession of heroin is charged in count 3, and possession of drug paraphernalia is charged in count 4. As to counts 1, 2, and 3, you'll be sentenced to 22.05 months in the Florida Department of Corrections with credit for 149 days that you've already served. Those sentences will run concurrent with each other and concurrent with the sentence imposed in case 19 CF 3758. As to count 6, you'll be sentenced to 149 days in the county jail, credit for 149 days time served. Again, running concurrent with all other counts and cases. You are ordered to pay court costs of $415, a $100 cost of prosecution, a fine of $250. There is a required court cost of $15 pursuant to Florida Statute 938.13 for the misdemeanor drug offense, $201 pursuant to Florida Statute 938.08 for the battery on a law enforcement officer, as well as $151 pursuant to Florida Statute 938.085 for the battery on the law enforcement officer. There'll be a $100 public defender lien and $50 public defender application fee. All of the money that you are ordered to pay is ordered to be paid through the clerk's collection program at the rate of no less than $50 every month. Payments will be consecutive to the payments that were ordered in case 19 CF 3758. So you pay off the one case first, and you start paying the second case, all at $50 a month. Driving privileges are ordered suspended for a period of 6 months as to count 3. Okay. The court has no objection to you obtaining a business purposes license if you otherwise qualify. Is there anything further with respect to the sentences?
No, Your Honor.
Okay. And you'll be not processing counts 4 and 5? Okay. Mr. Figueroa Flores, you have 30 days within which you can appeal the judgments and sentences that were entered in your cases. If you want to appeal and you are unable to afford to hire a lawyer to assist you, I will appoint one. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
All right. Thank you. Good luck to you. Okay. We have Terrence Blaine.
John Zawinski from Mr.
All right, good morning, Mr. Blaine.
morning, Your Honor.
I don't know if, raise your right hand. You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth?
I do.
State your name, sir.
Terrence Jerome Blaine.
Okay. Madam Clerk, I'm not sure what the angle is. I know they can see me. but, Mr. Blaine, you're here this morning in case 19 CF 3508. And Mr. Zaleski, your lawyer, has submitted a written plea form in this case, which indicates you wish to enter pleas of no contest to burglary of a conveyance as charged in count 1 and to petty theft with 2 or more prior theft convictions as charged in count 2. Is that what you wish to do, sir?
Correct, sir.
Each of those 2 charges is a third-degree felony, which is punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes, I do.
All right. Now, the plea form that was submitted appears to have your signature on it. Did you read and understand this written plea form?
Yes, sir, I did.
And is that your signature on the plea form?
Yes, sir, I suppose so.
Okay. Well, it's true, you can't see it very well.
Correct.
But you did read and sign a plea form, is that correct?
Yes, sir, I did.
All right. Do you have any questions at all about anything on the written plea form?
No question.
Are you presently under the influence of medication or any type of drug or alcohol?
No, sir, I'm not.
Are you thinking clearly at this time?
Yes, sir, I am.
Did any person coerce or force you in any way to enter this plea?
No, sir.
The recommendation in this case is that you be adjudicated guilty of both counts. You be sentenced to the lowest permissible sentence under the Criminal Punishment Code, which would be 26.78 months in the Florida Department of Corrections as to each count, with credit for the time that you've served, which is, what's the time served?
232 days.
232 days that you've already served. You'd be required to pay a fine, court costs, regional conflict counsel lien, public defender application fee, cost of investigation of $342, and restitution of $585 to Jessica Danielle Rocker. Is that your understanding of the plea agreement?
Yes, sir, it is.
You've been represented by Mr. Zaleski. Are you satisfied with his representation of you in this case?
Yes, sir.
You believe it is in your best interest to enter the plea?
Yes, sir, I do.
Understand that if you are not a United States citizen, entering this plea will subject you to deportation.
Yes, sir.
If you've ever in the past been convicted of a sexually motivated or sexually violent crime, once you complete the prison sentence imposed by the court, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir, I do.
You do have the right to have a jury trial. If you elected to go to trial, you would be presumed to be innocent at trial. You could not be found guilty unless a jury unanimously found the state had proven your guilt beyond reasonable doubt. Do you understand? You understand that?
Yes, sir, I do.
Okay. You would have the right to be represented throughout your trial by Mr. Zaleski, and you would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You are entitled to use of the court's subpoena power to acquire any witnesses you may have to be present at the trial. You also have the right at trial to testify, or you could elect not to testify, and if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you elected not to testify as evidence of guilt. Do you understand that you have those rights?
Yes, sir.
By entering a plea of no contest, you're giving up each one of the rights that we've talked about, as well as the other rights that are written on the plea form, and there won't be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters at all relating to your case, other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
Very well. And State, would you be prepared to prove that prior to September 11th of 2019, that Mr. Blaine had on at least 2 occasions been convicted of theft or larceny?
Yes, sir.
All right. Mr. Blaine, I've read the affidavit for arrest warrant by Detective Malkowski, and based on that affidavit, together with the representation of the prosecutor, Mr. Kazira, I do find that there is a factual basis upon which your plea can be accepted as to each count. I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing, and you understand the rights that you're giving up by entering this plea. And I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've expressed satisfaction. I'll accept your plea of no contest. Mr. Zaleski, do you agree with the score sheet was 63.7 points?
Yes.
Is there anything further to be said before sentence is imposed, sir? All right, Mr. Blaine, you will be judged guilty of burglary with conveyance as charged in count 1 and petty theft with 2 or more prior theft convictions as charged in count 2. As to each count, you'll be sentenced to 26.78 months in the Florida Department of Corrections with credit for the 252 days that you've already served. 232? Okay, 232 days that you've already served. Those sentences will run concurrent with each other. You are ordered to pay court costs of $415, a $100 cost of prosecution, a fine of $500, a restitution of $585 to Jessica Danielle Rucker, a cost of investigation of $342 to the Osceola County Sheriff's Office, a $100 conflict counsel lien, and $50 public defender application fee. The money is all ordered to be paid through the clerk's collection program at the rate of no less than $50 every month. You'll have until April 1st of 2022 to make your first payment. Payments will be applied first towards restitution, then towards the other monies owed. You will be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. Mr. Blaine, you do have 30 days within which you can appeal the judgment and sentence just entered in this case. If you want to appeal and you are unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
All right, thank you, sir. Belsky, let's go ahead and address your other cases while you're here, if you're ready. We have a status hearing on Travis Miller.
Right, Judge. We have not had any contact with him for at least it's March 4th.
Mr. Miller was not present at the pretrial on May 26th, and we,
I believe he's scheduled for 9:30, Judge. I don't really know. All these people are 9:30.
oh, you're right. We are a little bit early, so we'll pass him for a few minutes. Thank you. All right, Michelle Mallender. Michelle Mallender, if you'll come on up. Ms. Mallender, please tell us your name.
Michelle Myron.
Okay, Ms. Mallender, oh, she's already been appointed. You're here for arraignment in case 19 CF 4208. You're charged in this case with burglary of a dwelling in count 1 and petty theft in count 2. Count 1 is a second-degree felony, which is punishable by up to 15 years state prison, up to 15 years probation, and/or a fine of up to $10,000. Count 2 is a misdemeanor punishable by up to 60 days in the county jail, 6 months probation, and/or a fine of up to $500. Do you understand what the charges are?
Yes, Your Honor. Not guilty, Your Honor.
I will accept your plea of not guilty. Your case is set for jury trial during the trial period, which will begin on August 24th. Pretrial will be on August the 12th. Once you receive your paperwork from the clerk this morning, you're free to go today. You need to make an appointment as soon as possible to meet with your lawyer. All right? Thank you. Marvin Rivera Sullivan. Okay, fair enough. Mr. Rivera Sullivan, if you'll raise your right hand, face the clerk.
Do you solemnly swear or affirm the testimony you shall enter in this case be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
State your name, please.
Marvin Rivera Sullivan.
Mr. Rivera Sullivan, did you fill out and sign this application for criminal indigent status?
I did.
Is the information that you wrote on the affidavit the truth?
It's the truth.
All right. Now, you indicate you have a bank account. Approximately how much money do you have in your bank account?
Right now, $100.
I'm sorry?
$100.
$100? Okay. All right, based on your affidavit and testimony, I find that you are indigent. I will appoint the office of the public defender to represent you in case 14 CF 2856. You were placed on probation in this case for grand theft. You've been accused of violating that probation. It is alleged that you violated condition 2 by failing to pay the cost of supervision as ordered, that you violated condition 9 by failing to complete the community service hours as ordered, and as instructed by your probation officer. It's alleged you violated condition 9 by failing to comply with the instruction of your probation officer to make monthly payments as ordered, that you violated condition 10 by failing to pay the fines and court costs, restitution as ordered, that you did actually fail to complete the community service hours as ordered. Do you understand what you've been accused of?
We enter a denial at this time, Your Honor.
I will accept the denial of the violations. Mr. Rivera Sullivan, your case is set for a violation of probation hearing on August the 20th. There'll be a status hearing on August 18th. You're here on both those dates. You need to meet with your attorney as soon as possible. I don't know if you're able to come into compliance, but if you are able to come into full compliance before the hearing, I would dismiss the violation. So you can talk to your attorney about that. Thank you. Luis Beltran Guzman.
Good morning, Your Honor. This is Flavia Rodriguez, state certified court interpreter, not sworn in today.
Rodriguez, do you solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability?
I do, to the best of my ability, Flavia Rodriguez, state certified court interpreter.
Mr. Beltran Guzman is at the jail, and we're seeing him over video, so he does not have the headset on. Mr. Beltran Guzman, if you'll please raise your right hand.
Señor Beltrán Guzmán, por favor, levante la mano derecha.
You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Juro solemnemente y promete que el testimonio que presentará será la verdad, toda la verdad y nada más que la verdad. ¿Lo juro ante Dios?
Sí.
Yes.
Please tell us your name, sir.
Luis Beltrán.
Luis Beltrán.
Okay, and I understand, Mr. Beltran Guzman, that you do understand a fair amount of English, but even if you understand what I'm saying, I'll ask you wait until the interpreter interprets it so we don't get confused.
Entiendo, señor Guzmán, que usted comprende gran parte de lo que se dice en inglés, pero le pido que, por favor, aunque sea así, espere a que el intérprete termine de interpretar para evitar confusiones.
Listo.
That's fine.
Okay, thank you, sir. Mr. Beltran Guzman, Mr. Mendoza has provided the court with a written plea form that indicates you wish to resolve this case by entering pleas of guilty to traveling to meet a minor for an unlawful sexual act as charged in count 2, attempted lewd or lascivious battery as charged in count 3, and transmission of material harmful to a minor as charged as this all counts 4 through 15.
Judge, for the record, Richard Mendoza, covering for Miss.
I'm sorry, Your Honor. May I be allowed to interpret so far?
Yes.
Señor Beltrán Guzmán, el licenciado Mendoza nos ha entregado un formulario declaratorio en el que indica que usted se quiere declarar culpable por la acusación de llevar a un menor a cometer una actividad sexual ilegal, que es el cargo 2, un cargo de abuso lascivo o deshonesto, que es el cargo 3, y causar daño a un menor, los cargos 4 hasta el 15.
Sí.
Yes.
And Mr. Mendoza,
And Judge, I was trying to make sure how we structured the plea form. I'm looking at the counts, and I don't know if she had probation on all of the counts, but a lot of them are just third-degree felonies, so I'm okay just doing probation on count 2, which is the second-degree felony, and it would be certain sex offender conditions. We have, I'm like right by the microphone, but
it's just go in blocks of.
oh, for the interpreter. Sorry, Madam Interpreter, you can go ahead.
Estoy mirando el formulario declaratorio, quería que quedara claro con respecto a la libertad vigilada. Son la mayoría delitos de tercer grado, por lo tanto me parece bien que la libertad vigilada sea en el segundo cargo, que es el que es delito de segundo grado, y se impongan ciertas condiciones adicionales por casos de ser un ilícito sexual.
Since that particular count isn't mandatory for sex offender probation, it is regular probation, but with some special conditions from sex offender probation. So we have attached those conditions, the ones that apply to him are circled that he's agreeing to do.
Ya que en ese segundo cargo no es obligatorio, las condiciones será libertad vigilada regular, pero se impondrán condiciones especiales por casos de índole sexual. Hemos anexado esas condiciones y circulado en verde las que aplican en este caso.
Okay. Mr. Mendoza, did you have something to?
And my understanding is that it was I'm sorry, Your Honor. What I would like to add is that it was a plea to count 2 through 16.
Yes.
And, of course, adjudication of guilt, 4 years DOC, followed by 5 years supervised probation.
Okay.
I think that's how it's written out there.
All right, that's all clear on the plea form.
Okay.
Licenciado Mendoza, ¿quiere agregar algo más? Bueno, me queda entendido que Bueno, mis disculpas. Lo que quería agregar es que esto va del cargo 2 al 16, que serán 4 años en el Departamento de Correccionales, seguido por 5 años de libertad vigilada. Y todo eso está claro en el formulario declaratorio.
It seems that, well, we could do it, there's some flexibility as to how to do the DOC and the probation. You could actually do sex offender probation and the attempted lewd lascivious battery.
Yeah, actually,
It might make sense to
yeah,
do the DOC as to the count 2 and do concurrent
probation on the other.
as to other.
Yep, that's actually much easier. Thank you.
Me parece que tenemos alguna flexibilidad con respecto a la sentencia carcelaria y la libertad vigilada, como es un caso de índole sexual. Lo que podemos hacer es que la sentencia carcelaria sea por el cargo 2, sea concurrente y luego la libertad vigilada. Sí, eso nos parece mucho mejor.
All right, Mr. Beltran Guzman, the charge of traveling to meet a minor for an unlawful sexual act is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Do you understand?
Bien, señor Beltrán Guzmán, el cargo de haber viajado para encontrarse con un menor y cometer un acto sexual ilegal es un delito de segundo grado y acarrea una sentencia máxima de 15 años en departamentos correccionales, 15 años de libertad vigilada o hasta $10,000 en multa. ¿Usted entiende eso?
Sí, entiendo, sí, señor.
Yes, yes, I understand. Yes, sir.
Okay. Each of the other charges in counts 3 through 16 are third-degree felonies, which are each punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. You understand?
El resto de los otros cargos del 3 al 16 constituyen delitos de tercer grado que pueden ser sancionables cada uno por un máximo de 5 años de prisión estatal, 5 años de libertad vigilada o hasta $5,000 en multa. ¿Usted entiende eso?
Sí, entiendo, sí, señor.
Yes, I understand. Yes, sir.
And Mr. Mendoza has provided a 4-page written plea form. Did you read and understand the written plea form?
Y el licenciado Mendoza nos ha entregado un formulario declaratorio que es un documento de 4 páginas. ¿Usted lo leyó y lo entendió?
Sí, yo lo entendí.
Yes, I understood it. Yes.
And Mr. Mendoza, you're standing in for Ms. Smith?
Yes, I am.
Okay. So Ms. Smith is your lawyer in this case, but Mr. Mendoza's standing in for the purpose of this plea. Do you understand that?
Señor, usted entiende que el licenciado Mendoza es el licenciado que está cubriendo en este caso para propósitos del convenio. ¿Entiende eso?
Sí, lo entiendo, perfecto.
Yes, I understand. Perfect.
Did you have a chance to go over the plea form with Ms. Smith?
¿Usted tuvo la posibilidad de repasar el formulario declaratorio con la licenciada Smith?
Sí, sí, toda la oportunidad.
Yes, yes, I had the chance.
And did you understand everything on the written plea form?
¿Y usted entendió todo lo que dice este formulario declaratorio?
Sí, perfecto.
Yes.
Sí, señor.
Perfectly well. Yes, sir.
There's also a second form that's in English that's titled Special Conditions for Sex Offenders pursuant to Florida Statute 948.30. Did you go over that form with Ms. Smith?
Además, hay un segundo documento que está en inglés, que es el documento que explica las condiciones especiales de la libertad vigilada para y en general para los casos de índole sexual, que establece lo que explica el artículo de ley número 943.30. ¿Usted además repasó ese documento con la licenciada Smith?
Sí,
Well, yes.
Did she have an interpreter assist with explaining that form to you?
Ella utilizó un intérprete para que le asistiera a explicarle este formulario a usted.
sí, ella hizo eso. Correcto.
Yes, she did that. Yes.
Okay. All right, Mr. Beltran Guzman, are you thinking clearly here today?
Bien, señor Beltrán Guzmán, en la mañana del día de hoy usted está pensando claramente.
Sí,
Yes.
Are you under the influence of any medication or other types of drug or alcohol?
¿Usted se encuentra bajo los efectos de algún tipo de medicamento, alguna droga o alguna bebida alcohólica?
No, señor.
No, sir.
Has any person coerced or in any way pressured or forced you to enter this plea?
¿Alguien le obligó, le coaccionó, le presionó de alguna manera para que usted aceptara esta oferta?
No, señor.
Well, no, sir.
The recommendation in this case is that you would be adjudicated guilty of all counts to which you are pleading.
La
And
recomendación en este caso es que se emita fallo de culpabilidad por todos los cargos ante los cuales usted se declara.
and the agreement is that the court would impose a downward departure sentence of 4 years in the Florida Department of Corrections with credit for 44 days time served.
Y que se imponga una sentencia que es una reducción de la pena mínima, que serán 4 años en el Departamento Correccional del Estado de la Florida, acreditándole 44 días que ya usted tiene cumplidos.
And that 4-year prison sentence would be followed by 5 years of sex offender probation.
Y que esa sentencia carcelaria de 4 años se vea luego seguida por 5 años de libertad vigilada para casos de índole sexual.
And the clerk tells me that you actually have credit for 144 days time served.
Y la secretaria me comunica que de hecho el crédito que usted tiene son 144 días ya cumplidos.
So is that your understanding of the plea agreement?
Entonces, señor, le queda entendido que ese es el convenio.
Sí, señor.
Yes, sir.
Are you fully satisfied with the representation you received from Ms. Smith and Mr. Mendoza in this case?
¿Se siente usted completamente satisfecho con la representación legal que recibió de la licenciada Smith y del licenciado Mendoza en esta causa?
Sí, me siento satisfecho, sí, señor.
Yes, I am satisfied. Yes, sir.
You believe it is in your best interest to enter this plea?
¿Y usted considera que aceptar este convenio es lo más conveniente para usted?
Sí, señor.
Well, yes, sir.
You understand that if you are not a United States citizen, entering this plea will subject you to deportation.
¿Usted entiende que si no es ciudadano de los Estados Unidos, al aceptar este convenio lo dejará sujeto a deportación?
Sí, señor.
Yes, sir.
Due to the nature of the charges in this case, once you complete any prison sentence the court imposes, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Teniendo en cuenta la naturaleza de estos cargos, una vez que usted termine la sentencia carcelaria, usted podría quedar sujeto a internamiento forzoso civil, considerándosele como depredador sexual. ¿Usted entiende eso?
Sí, entiendo, sí, señor.
Yes, I understand. Yes, sir.
And that same possibility would apply if you were ever convicted of another crime of any kind and sentenced to prison in Florida after your release in this case. You understand?
Y esto mismo podría ocurrir si en algún momento en el futuro usted comete otro ilícito y es sentenciado a tiempo de prisión en el estado de la Florida. Podría ocurrir luego de que cumpla esa sentencia. ¿Entiende eso?
Sí, ya entiendo, sí, señor.
Yes, I understand. Yes, sir.
All right. You do have the right to have a jury trial in this case to determine whether the state can prove that you committed these crimes. Do you understand?
Usted tiene el derecho a que se proceda a un juicio en esta causa y en ese juicio la fiscalía tendría que demostrar que usted cometió estos ilícitos. ¿Se entiende eso?
Sí, señor.
Yes, sir.
If you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond and to the exclusion of every reasonable doubt. Do you understand?
Durante ese juicio a usted se le presumiría inocente y no se le podría hallar culpable a menos que un jurado de manera unánime determine que la fiscalía ha demostrado su culpa más allá de toda duda razonable. ¿Usted entiende eso?
Sí, señor.
Yes, sir.
All right. If you chose to go to trial, you would have the right to be represented throughout the trial by Ms. Smith and/or Mr. Mendoza, and you would have the right to confront and cross-examine any witnesses who testified against you. Do you understand?
Si usted decidiera proceder a juicio, usted tendría el derecho a que la licenciada Smith o el licenciado Mendoza le representen durante la totalidad de ese juicio y interroguen y cuestionen a los testigos que vengan a declarar en su contra. ¿Entiende eso?
Sí, entiendo, sí, señor.
Yes, I understand. Yes, sir.
You would have the right to present any witnesses or evidence you may have in your defense at your trial, and you have the right to have the court order any witnesses you have be present so you can present their testimony. Do you understand?
Usted tiene el derecho a presentar durante el juicio todo testigo o defensa que usted tenga en su caso y tiene el derecho a que el tribunal ordene a los testigos a comparecer y declarar a su favor. ¿Entiende eso?
Sí, señor.
Yes, sir.
You would also have the right to testify yourself at trial, or you could choose not to testify. And if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand?
Además, usted tiene el derecho ya sea a declarar durante el juicio o a permanecer en silencio. Si usted decidiera permanecer en silencio y no declarar, tiene el derecho de que se le instruya al jurado que no pueden considerar esto como prueba de culpa. ¿Entiende eso?
Sí, señor.
Yes, sir.
By entering a plea of guilty, you're giving up all the rights we've talked about, as well as the other rights that are written on the plea form, and there will not be a trial in your case. Do you understand?
Al declararse culpable, usted renuncia a estos derechos y al resto de los derechos que consta en el formulario y no procederemos a juicio en su caso. ¿Entiende eso?
Sí, señor.
Yes, sir.
You also are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Además, usted renuncia a la mayor parte de sus derechos apelatorios, excluyendo la jurisdicción de este tribunal sobre el caso y la legalidad de la sentencia. ¿Entiende eso?
Sí, señor.
Yes, sir.
All right, Mr. Beltran Guzman, do you have any questions at all about your rights or about this plea?
Bien, señor Beltrán Guzmán, ¿tiene usted alguna pregunta con respecto a sus derechos o con respecto a este formulario?
No por el momento.
Not at this time, Your Honor.
All right, I find that you are alert and intelligent, that you understand the nature of the charges against you as well as the penalties that you're facing.
Bien, determino que usted es consciente de sus actos, que entiende la naturaleza de las acusaciones en su contra y las sanciones que enfrenta.
Sí, entiendo. Sí, señor.
Yes, I understand. Yes, sir.
I further find that you understand the penalties that you're facing in this case and the rights that you're giving up by entering this plea.
Además, determino que usted entiende las sanciones que enfrenta en este caso y los derechos a los que renuncia al aceptar el convenio.
I find that your decision to enter the plea has been freely and voluntarily made and that you have had the advice of competent counsel with whom you've expressed satisfaction.
Determino que usted ha tomado de manera libre y voluntaria la decisión de aceptar el convenio en este caso, siendo asesorado por abogados competentes con quien me ha dicho se siente satisfecho.
Sí, señor.
Yes, sir.
I find that you've had the advice of competent counsel with whom you've told me you're satisfied.
Determino que le han asesorado abogados competentes con quien me ha dicho se siente satisfecho.
And I find
Yes, sir.
I find that there's a factual basis upon which this plea can be accepted based on the arrest affidavit by Deputy Marrero Mosa.
Y determinó que existe el fundamento fáctico que sustenta las acusaciones en su contra, según lo que establece la affidavit acusatorio firmado por el alguacil Marrero Mosa.
Sí, señor.
Yes, sir.
So I will accept the plea of guilty. Mr. Mendoza, does the defense agree with the score sheet with 154.2 total sentence points?
Yes, Your Honor, we have no objections to the score sheet. as
I'm
written.
sorry, Your Honor. Did you say 154.2?
Right.
En la hoja de cálculo del acusado asciende a 154.2 puntos.
Your Honor, we have no objection to the score sheet as written, and we also waive PSI pursuant to a negotiated plea.
Su señoría, no tenemos objeción a la hoja de cálculo tal y como se ha planteado y además renunciamos al informe precondenatorio, según lo que establece el convenio.
Okay, and state you are recommending a downward departure sentence, is that correct?
Yes, Your Honor.
Y la Fiscalía recomienda que se reduzca la pena mínima, ¿cierto? Sí.
All right, Mr. Beltran Guzman, this time you will be adjudged guilty of traveling to meet a minor for an unlawful sexual act as charged in count 2. Attempted lewd or lascivious battery is charged in count 3. And transmission of material harmful to minors in counts 4 through 16.
Bien, señor Beltrán Guzmán, en este momento dado se emite fallo de culpabilidad por la acusación de haber viajado para encontrarse con un menor y cometer un acto sexual en el segundo cargo. Tercer cargo, tentativa de abuso lascivo y libidinoso. Y cargos 4 al 16, transportar material que le causaría daño a un menor.
As the court will, pursuant to the uncoerced plea agreement between yourself and the state, the court will impose a downward departure sentence in this case.
Según las negociaciones establecidas entre usted y la Fiscalía, se impondrá una reducción de la pena mínima en este caso.
As to count 2, you'll be sentenced to 4 years in the Florida Department of Corrections with credit for 144 days time served.
Por el segundo cargo se le sentencia a usted a 4 años en el Departamento de Correccionales de la Florida, acreditando los 144 días que ya tiene cumplido.
As to count 3, you'll be placed on 5 years sex offender probation to run consecutive to the prison sentence imposed in count 2.
Por el cargo 3 se le imponen 5 años de libertad vigilada para casos de índole sexual, que correrán de manera consecutiva con respecto a los 4 años de sentencia carcelaria por el cargo 2.
As to counts 4 through 16, you'll be placed on 5 years probation, running concurrent with the probation imposed in count 3 and consecutive to the prison sentence imposed in count 2.
Y con respecto a los cargos 4 al 16, se le impondrán 5 años de libertad vigilada para casos de índole sexual, que correrán de manera concurrente con la sentencia de 5 años de libertad vigilada del cargo 3 y de manera consecutiva con la sentencia carcelaria del cargo 2.
As to count 3, the court will impose all standard conditions of probation as well as all applicable conditions under 948.30, including specifically electronic monitoring as a condition of probation.
Se impondrán las condiciones estándares de la libertad vigilada con respecto al cargo 3, así como el resto de las condiciones especiales que se establecen en el artículo de ley 948.3, incluyendo el uso de monitoreo electrónico.
As to counts 4 through 16, court will impose standard conditions of probation, plus the following enunciated special terms of condition, terms of probation.
Por los cargos contra el 16 se imponen las condiciones estándares de la libertad vigilada, además de los términos especiales que ya se han mencionado.
First, you will maintain a mandatory curfew from 10 o'clock p.m. to 6 o'clock a.m. 7 days a week.
Usted mantendrá un toque de queda obligatorio de 10 de la noche a 6 de la mañana los 7 días de la semana.
Second, you will not live within 1,000 feet of a school, daycare center, park, playground, or other places where children normally congregate.
Usted no podrá vivir a menos de 1,000 pies de una escuela, parque, centro de congregación de menores, cualquier lugar donde se puedan reunir menores.
Third, you will actively participate in and successfully complete a sex offender treatment program.
Tercera condición, usted participará y culminará satisfactoriamente un programa de tratamientos para personas que han cometido ilícitos de índole sexual.
You will be required to enter such a program within the first 90 days of your probation and work diligently towards completing that program.
Tiene que matricularse en ese programa en los primeros 90 días de su libertad vigilada y hacer todo lo necesario de manera diligente para concluir el programa.
Do not have intentional contact with any child under the age of 18.
No puede tener contacto intencional con ningún menor de 18 años.
Unless the court approves after considering the factors set forth in Florida Statute 948.30, sub 1, sub E.
A menos que se haya aprobado anteriormente, teniendo en cuenta lo que establece el artículo 948.30.
You are prohibited from working for pay or as a volunteer at any place where children regularly congregate.
Se le prohíbe trabajar, ya sea recibiendo un salario o de manera voluntaria, en cualquier lugar en el que se congreguen niños.
You will not view, own, access, or possess any obscene, pornographic, or sexually stimulating material.
Se le prohíbe a usted tener, acceder o simplemente tener posesión de cualquier material pornográfico o cualquier material estimulante sexual.
You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database.
Tiene usted que entregar una muestra biológica para que se incluya en la base de datos de la Policía Estatal de la Florida.
You'll be required to submit to warrantless search by the probation office of your person, residence, or vehicle.
Su agente de la libertad vigilada podrá llevar a cabo registros a su persona, vivienda o vehículo sin necesidad de que exista una orden.
You will participate at least annually in a polygraph examination for risk management and reduce denial mechanisms.
Usted se someterá al menos una vez al año a pruebas de polígrafo para evaluar los riesgos y reducir cualquier tipo de mecanismo de negación.
You're required to maintain a driving log and are prohibited from driving a motor vehicle alone without prior approval from your probation officer.
Usted tiene que mantener una base de datos o tarifa de sus viajes de conducción y no puede conducir estando solo en el vehículo a menos que anteriormente lo haya aprobado así su agente de la libertad vigilada.
As previously indicated, you'll be required to submit to electronic monitoring.
Como se indicó anteriormente, usted queda sujeto a monitoreo electrónico.
You are prohibited from accessing the internet or other computer services until after your sex offender treatment program and after a risk assessment is completed and a safety plan approved by the court.
Se le prohíbe a usted usar el internet o acceder a computadoras hasta tanto haya terminado su programa de tratamiento, se haya llevado a cabo una evaluación de riesgos y se haya puesto en vigor un plan de seguridad por parte del juzgado.
You'll be required to comply with all the rules of electronic monitoring.
Tienen que cumplir con todas las reglas del monitoreo electrónico.
You are ordered to pay court costs of $415, a $100 cost of prosecution, a fine of $500, a $100 public defender lien, and $50 public defender application fee.
Tienen que pagar $415 en costas judiciales, $100 en costas de enjuiciamiento, multa de $500, $100 en honorarios del defensor público y $50 por la solicitud del defensor público.
The money is ordered to be paid at the rate of no less than $50 every month, beginning no later than the fourth month of your probation.
Deberá pagar un mínimo de $50 al mes, comenzando a saldar esta deuda lo más tardado en el cuarto mes de su libertad vigilada.
You will be required to report to the State Probation Office here in Osceola County no later than 2:00 p.m. on the next business day following your release from the Department of Corrections.
Se reportará a la libertad vigilada, y esto será un requerimiento, reportarse a la libertad vigilada estatal del condado de Osceola lo más tardado, 2 de la tarde del siguiente día, luego de que usted sea puesto en libertad de la cárcel.
Was there anything further with respect to sentence?
As to count one, Your Honor, the state will announce a no pause.
I'm sorry, Your Honor. May I please request that the attorney approaches the microphone?
Sorry, as to count one, the state will announce a no pros.
La Fiscalía anuncia que desestimará el primer cargo.
All right.
Nothing from defense, Your Honor.
Mr. Beltran Guzman, you have 30 days within which you can appeal the judgment and sentence was just entered.
Bien, nada más que agregar por parte de la defensa. Señor Beltrán Guzmán, usted tiene 30 días si desea apelar el fallo y sentencia que se acaba de asentar.
If you want to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you.
Si usted quisiera apelar y no se pudiera costear los servicios de un abogado, se le designaría uno para que le represente.
If you do not file an appeal in writing within 30 days, you waive your right to appeal. You understand?
Si usted no hubiera apelado por escrito en un plazo de 30 días, habría cedido su derecho a apelar. ¿Entiende eso?
Sí, señor.
Yes, sir.
Thank you, sir.
Thank you, Judge.
Gracias, señor. I'm sorry, Your Honor. May the interpreter please request the case number?
Yes, it's 20 CF 183.
I'm sorry, Your Honor.
20 CF 183.
Thank you so much.
Thank you.
Is that it for the moment?
That's it. Thank you.
Thank you. Have a good morning.
The defendant is present. He does not have the headset on. So, Mr. Brito, if you'll please raise your right hand and be sworn.
Levanta la mano para que preste juramento.
Sorry, Mr. Leal, are you with us?
Yes, Your Honor.
Okay. I'm asking that Mr. Brito raise his right hand and be sworn.
Señor Brito, levante la mano derecha para que preste juramento.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Jura y afirma que el testimonio que hará será la verdad, toda la verdad y nada más que la verdad. ¿Lo jura?
Sí.
Yes.
Tell us your name, please.
Díganos su nombre, por favor.
Carlos Santana.
Carlos Santana.
All right, Mr. Santana, you are here in 4 cases this morning.
Señor Santana, usted está aquí en 4 casos en esta mañana.
In case 20 CF 479,
Caso 20 CF 479.
I'm told you wish to enter a plea of no contest to delivery of a controlled substance as charged in count 1.
Dice que va a declaración, no me pongo el cargo de envío de sustancias reguladas o controladas, cargo número 1.
And to delivery of or possession with intent to deliver or manufacture of drug paraphernalia as charged in count 2.
Y también el cargo por el tráfico de, o tener en su poder o confeccionar sustancias reguladas en el cargo número 2.
Is that what you want to do, sir? Is that what you want to do, sir?
¿Es esto lo que usted desea hacer, señor?
Sí.
Yes.
Okay, in case 20 CF 481, the plea form indicates you wish to enter a plea of no contest to delivery of a controlled substance as charged in count 1 and delivery or possession with intent to deliver or manufacture drug paraphernalia as charged in count 2. Is that what you want to do in that case?
Entonces usted lo que desea hacer es declarar eso no lo pongo, tanto en el cargo de tráfico de sustancias reguladas y el cargo de intento o tenencia o confección de artículos para uso de droga en el segundo cargo. ¿Eso es todo lo que usted desea hacer?
Sí.
Yes.
All right. In case 20 CF 482, the plea form again indicates you wish to enter pleas of no contest to delivery of heroin as charged in count 1 and delivery or possession with intent to deliver or manufacture drug paraphernalia as charged in count 2. Is that what you want to do in that case?
Y en la hoja del acuerdo declaratorio se indica que en ese caso, el 20 CF 482, también se quiere declarar no me opongo por el caso de tráfico de heroína con intento de vender y el segundo caso de tenencia o intento de confeccionar o de distribuir droga en el cargo número 2. ¿Eso es lo que desea hacer?
Sí.
Yes.
Okay, and finally, in case 20 CF 483, the plea form indicates you wish to enter pleas of no contest to delivery of heroin as charged in count 1 and delivery or possession with intent to deliver or manufacture drug paraphernalia as charged in count 2. Is that what you wish to do in that case?
Y en el otro caso, el 20 CF 483, el acuerdo declaratorio indica que se quiere declarar no me opongo, tanto del tráfico de heroína en el cargo número 1, como en el cargo 2 de intento de tenencia o intento de confeccionar drogas en el cargo número 2. ¿Es eso lo que desea hacer?
Sí.
Yes.
I've been given written plea forms in each of these cases that appear to have your signature and initials on them. Did you sign and initial these plea forms?
Y en el formulario que tengo para cada caso indica que está su firma, también están colocadas sus iniciales. ¿Esas son sus firmas y sus iniciales que están escritas en ese acuerdo declaratorio?
Sí.
Yes.
These are Mr. Smith's cases.
Yes, Your Honor.
Did you go over these plea forms with Ms. Smith?
¿Usted ya revisó estos formularios de declaración con la señora Smith?
Sí.
Yes.
Did she have an interpreter available when you went over the plea forms with her?
Y cuando revisaron el formulario de declaración, ¿ella tenía un intérprete o traductor disponible para hacerlo?
Sí.
Yes.
Did you understand everything on the written plea forms as explained to you?
¿Usted entendió el contenido del formulario de declaración y todo lo que se le explicó?
Sí.
Yes.
Do you have any questions about anything on the written plea forms?
¿Alguna pregunta al respecto de lo que aparece en el formulario de declaración?
No.
No.
Are you currently under the influence of medication or any other kind of drug or alcohol?
¿Está usted bajo los efectos de algún medicamento, droga o alcohol?
No.
No.
Are you thinking clearly this morning?
¿Usted está pensando claridad en esta mañana?
Sí.
Yes.
Did any person coerce or force you in any way to enter these pleas?
¿Alguna persona lo presionó a usted o lo obligó a que usted suscribiera estos acuerdos declaratorios?
No.
No.
The recommendation is that the court impose a downward departure sentence in these cases.
La recomendación es que el tribunal imponga una pena disminuida en estos casos.
If I accept your pleas, the sentence would be, you would be adjudicated guilty of all counts.
Si yo se acepta este acuerdo declaratorio, usted quedaría culpable de todos estos cargos.
You'd be required to serve 115 days in the Osceola County Jail with credit for 115 days' time served.
Se requeriría que usted purgue 115 días de cárcel, pero se le daría el crédito carcelario por los 115 días ya cumplidos.
That will be followed by 24 months of drug offender probation.
24 meses de régimen de prueba para infractores de delitos sexuales, delitos de drogas.
I apologize, that would be 24 months of community control with drug offender conditions.
24 meses de control comunitario con condiciones relacionadas con el consumo de drogas.
Which would be followed by 32 months of drug offender probation.
Más los 32 meses de periodo de prueba para infractores que cometen delitos relacionados con las drogas.
And that would be as to all counts running concurrent.
Pero todas las penas se van a imponer de manera simultánea.
You'd be required to pay a fine, court costs, public defender lien, and application fee.
Tendrá que pagar las multas, tendrá que pagar las cuotas judiciales y también la deuda pendiente con la Defensoría Pública.
You'd also be required to enter and successfully complete the Phoenix House Residential Drug Treatment Program.
Y tiene que inscribirse y concluir exitosamente el programa de rehabilitación del Centro Phoenix.
Is that your understanding of the plea agreement?
Así fue como usted entendió que era un acuerdo declaratorio.
Sí.
Yes.
Are you satisfied with your lawyer in these cases?
¿Está satisfecho con los oficios de su abogado en estos casos?
Sí.
Yes.
You believe it is in your best interest to enter these pleas?
¿Usted piensa que lo que más le conviene es suscribir estos acuerdos declaratorios?
Sí.
Yes.
Do you understand that if you are not a United States citizen, entering these pleas will subject you to deportation?
Entiende que si usted no fuera ciudadano estadounidense, el suscribir estos acuerdos lo expone a una deportación. ¿Entiende?
Sí.
Yes.
If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence imposed by the court, you could be committed civilly as a sexually violent predator. Do you understand?
Si en el pasado usted ha sido condenado por algún delito de índole sexual o de índole sexual violento, al concluir con esta sentencia sería recluido forzosamente en un centro o internado civil. ¿Entiende?
Sí.
Yes.
Right, Mr. Santana, you have the right in each one of these 4 cases to have a jury trial to determine whether the state can prove that you committed these crimes.
Señor Santana, en cada uno de estos casos usted tiene derecho de que se celebre un juicio ante un jurado para ver si la Fiscalía puede determinar y comprobar los casos que hay en su contra.
If you chose to go to trial, you are entitled to a separate trial in each of the 4 cases.
Y si usted fuera a un juicio, tendría derecho a que se hagan juicios por separado en cada uno de esos casos.
At each one of your trials, you would be presumed to be innocent, and you could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt.
Y si usted va a cada uno de estos juicios, usted sería presuntamente inocente, no puede ser hallado culpable a menos que un jurado de manera unánime determine su culpabilidad más allá de cualquier duda razonable.
You understand?
¿Comprende?
Sí.
Yes.
You'd have the right to be represented by your lawyer throughout the trial, each of your trials, and you'd have the right to confront and cross-examine any witnesses who testified against you. You understand?
Y entiende usted que usted tendría derecho a ser representado por su abogada en cada etapa de cada uno de los juicios y que también tiene derecho a contrainterrogar y a examinar a cualquiera de los testigos que sean presentados en su contra. ¿Entiende?
Sí.
Yes.
You would have the right to present witnesses and evidence in your defense at trial, and you have the right to have the court order any witnesses you have be present at your trial. Do you understand?
Y también tiene derecho a emplazar testigos que estén a su favor, sus propios testigos de la defensa en el juicio, y también de que sea el tribunal quien emplace a cualquier testigo a venir a declarar a su favor en el tribunal. ¿Entiende?
Sí.
Yes.
You also have the right at each trial to testify yourself, or you can choose not to testify. And if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. You understand?
Usted también tendría derecho a ser su propio testigo, a dar testimonio, y si usted elige no testificar en un juicio, tiene derecho a que al jurado se le instruya que no considerar la falta de testimonio como una conclusión de culpabilidad. ¿Entiende?
Sí.
Yes.
By entering pleas of no contest, you're giving up the rights we've talked about, as well as the other rights on the written plea forms, and there will not be a trial in any of your cases. Do you understand?
Al declararse no me opongo como lo ha hecho de estos casos, usted está renunciando al derecho de ir a un juicio, como aparece en el acuerdo declaratorio, y el derecho de que se le indique al jurado todos los principios relacionados con el juicio. ¿Entiende?
Sí.
Yes.
You also are waiving your right to appeal any matters relating to these cases other than this court's jurisdiction to hear the cases and the legality of any sentence the court might impose. Do you understand?
Y también estaría cediendo el derecho de apelación a la pena que se imponga, con la excepción de si podría apelar a la jurisdicción o autoridad que tenga este tribunal, en caso de que no la tenga, y a la legalidad de la sentencia si la sentencia no fuera legal. ¿Entiende?
Sí.
Yes.
All right. Ms. Santana, I've read the affidavit for arrest warrant in each case by Agent Jakara Miles.
Ya yo leí también el affidavit de arresto de la agente de Cara Miles.
Based on those affidavits, I find that there's a factual basis in each case upon which your pleas can be accepted.
Y basándome en lo que he leído en ese documento, veo que sí hay base jurídica para aceptar estos casos.
I find that you are alert and intelligent, and that you understand the nature of the charges against you and the penalties you're facing.
Usted es alerta, es inteligente y entiende la naturaleza de los cargos que está enfrentando.
I find that you understand the rights that you're giving up by entering these pleas.
Entiende los derechos que has cedido al suscribir este acuerdo declaratorio.
Sí.
Yes.
I find that your decision to enter these pleas has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you say you are satisfied.
Y también que usted ha procedido de manera libre, voluntaria, y que ha tenido la asesoría de una abogada competente con quien dice estar satisfecho.
So I will accept your pleas of no contest.
Así que acepto sus declaraciones de no me opongo.
Mr. Mendoza, do you agree with the score sheet with 68.9 points?
Yes, sir, we agree. We have no objections.
De acuerdo con el puntaje, 68.9 puntos, sin objeción.
You state you're recommending a downward departure sentence.
That's correct, Your Honor.
Correcto, su señoría.
Is it contemplated that he would remain in custody until Phoenix House picks them up, or?
Yes, Your Honor, and in conversations with Ms. Smith, as of last week, there is a bit of a wait time for Phoenix House.
Sí, hombre, periodo de lapso, eso fue lo que noté en mis conversaciones con la señora Smith.
I'm told that case 20 CF 482, he has credit for 116 days, the others are 115. State, any objection
To the extra day, no, Your Honor.
Ninguna objeción al crédito carcelario de 116 días y 115 días en el caso 26482.
All right, Mr. Santana, in case 20 CF 479, you will be adjudged guilty of delivery of a controlled substance as charged in count 1.
Entonces, el caso 479 te será hallado culpable de tráfico de una sustancia, como aparece en el cargo número 1,
And delivery of drug paraphernalia is charged in count 2.
y tráfico de adminículos para uso de droga en el cargo número 2.
As to each count, you'll be sentenced to 116 days in the Osceola County Jail with credit for 116 days time served.
En cada uno de los cargos se le impone una pena de la cárcel de 116 días, pero tiene el crédito carcelario de 116 días ya cumplidos.
That will be followed by 24 months of community control with drug offender conditions.
Seguido de 24 meses de control comunitario, cumpliendo con las normas para personas que cometen delitos relacionados con drogas.
Followed by 32 months of drug offender probation.
Y seguido con los 32 meses de prueba para personas que cometen delitos de drogas.
Your Honor, there was a conversation that I had with Ms. Smith that's not reflected on the form, which is that while he's on community control, I don't have any objection to him leaving Phoenix House to attend Phoenix House, whatever functions, so long as he's accompanied by someone from Phoenix House.
Sure.
Y hubo una conversación que tuve con la señora Smith, pero mientras él está en el centro de Phoenix House, bajo control comunitario, no hay ningún problema de que él salga del centro Phoenix House si él tiene actividades relacionadas con Phoenix House y esté acompañado o supervisado por alguien del personal.
All right, Mr. Santana, it's a required condition of your community control that you enter and successfully complete the Phoenix House Residential Drug Treatment Program.
Así que, señor Santana, es parte de este control comunitario que usted se inscriba y complete con éxito el programa de rehabilitación de drogas Phoenix House.
You'll be required to remain in the Osceola County Jail until a bed becomes available and then be transported directly from the jail to the Phoenix House program.
Usted permanecerá en la cárcel hasta que haya una cama o un cupo disponible en Phoenix House y cuando sea así será transportado directamente de la cárcel al lugar Phoenix.
It'll be a condition of your community control that you comply with all the rules and regulations of the Phoenix House program and that you remain in the program until you successfully complete it.
Y también como condición se impone de que usted cumpla y obedezca todas las normas y reglas de Phoenix House y que permanezca cumpliendo con ese programa hasta que lo termine con éxito.
You're ordered to pay court costs of $415, a $100 cost of prosecution, and a fine of $250.
Entonces deberá pagar la multa de $250, los $100 de procesamiento judicial y los $415 de costas judiciales.
$100 public defender lien and $50 public defender application fee.
$50 por la aplicación a la Defensoría Pública.
All of that money is ordered to be paid at the rate of no less than $50 per month, beginning with the 12th month of your community control.
Esa suma se irá cancelando por cuotas de $50 mensuales una vez que haya concluido el periodo de control comunitario de 12 meses.
I did not mention it. This sentence, as well as all the other sentences to be imposed this morning, are downward departure sentence pursuant to the uncoerced plea agreement.
Así que el acuerdo también con las otras penas es con la disminución de las penas que se imponen como se acordó.
In case 20 CF 481, you are judged guilty of delivery of a controlled substance as charged in count 1, and delivery of drug paraphernalia is charged in count 2.
Y en el caso 20481 es hallado culpable de tráfico de sustancias controladas, que montará el cargo número 1, y de tráfico de adminículos para uso de la droga, el cargo número 2.
As to each count, you'll be required to serve 116 days in the Osceola County Jail with credit for 116 days that you've already served.
En cada cargo se le pondría la pena de 116 días de cárcel, pero con el crédito carcelario que ya cumplió de los 116 días.
Be followed by 24 months of community control with drug offender conditions. Followed by,
Seguido los 24 meses de control comunitario, cumpliendo las condiciones para personas que cometen delitos de drogas.
which will be followed by 32 months of drug offender probation.
Seguido de los 32 meses de régimen de prueba para personas que sean infractores de asuntos de drogas.
These sentences in this case will run concurrent with the sentence in case 20 CF 479.
Esto será simultáneo también con el caso número 20 CF479.
The conditions with respect to the Phoenix House are the same as in case 20 CF 479.
Y las condiciones son las mismas referente al ingreso a Phoenix House, en el caso 479.
The fines, court costs, public defender lien, and application fee will be the same as imposed in case 20 CF 479.
Y será lo mismo en el caso 479 relacionado con lo que son los pagos a la Defensoría Pública, el pago de procesamiento judicial, las costas judiciales.
And the payment of those monies are ordered to be paid made at $50 per month consecutive to the payments ordered in case 20 CF 479.
Y las cuotas serán también de $50 de manera consecutiva en el caso 479.
In case 20 CF 482, you are judged guilty of delivery of heroin as charged in count 1 and delivery of drug paraphernalia is charged in count 2.
En el caso 27482 también se ha hallado culpable tanto por el tráfico de heroína, que es el cargo número 1, y el tráfico de adminículos para el uso de la droga en el cargo número 2.
As to each count, you're sentenced to 116 days in the county jail, cut for 116 days time served.
En ese cargo también son los 116 días de cárcel que se impone, pero dándole el crédito por los 116 días de cárcel ya cumplido.
Which will be followed by 24 months of community control with drug offender conditions, followed by 32 months of drug offender probation.
Con los 24 meses de control comunitario, con las normas para infractores de delitos de droga, seguido de los 32 meses de régimen de prueba para personas que cometen delitos de drogas.
The sentences as counts in case 20 CF 482 will run concurrent with the sentences in cases 20 CF 479 and 20 CF 481.
Los casos serán todos purgados de manera simultánea, tanto el caso 482, 479 y 481.
The conditions regarding entering and completing the Phoenix House program will be the same as imposed in case 20 CF 479.
Y también en el caso 479 serán las mismas condiciones en cuanto al ingreso y de rehabilitación en el centro Phoenix.
The fine, court cost, public defender lien, and application fee will be the same as imposed in case, in the same amounts as imposed in case 20 CF 479.
Y también, como se impone en el caso 20CF479, las mismas cuotas judiciales, también la aplicación a la Defensoría Pública y los costos de procesamiento judicial.
The money owed in case 20 CF 482 is ordered to be paid at $50 per month consecutive to the payments ordered in case 20 CF 481.
Y en el caso 20CF482 también van a ser $50 de cuota mensual de manera consecutiva, después, al igual que en el caso 20CF481.
Finally, in case 20 CF 483, you are judged guilty of delivery of heroin as charged in count 1, and delivery of drug paraphernalia as charged in count 2.
Y finalmente, en el caso 20CF483, también tendrá el caso número 1, que es el tráfico de heroína, y el caso número 2 de adminículos para uso de la droga.
You are sentenced to 116 days in the Osceola County Jail, credit for 116 days time served.
Se le ponen los 116 días de cárcel, pero tomando en cuenta los 116 días de crédito carcelario que ya cumplió.
I'll be followed as to each count by 24 months of community control of drug offender conditions, followed by 32 months of drug offender probation.
Será entonces seguido, se impondrá, los 24 meses de control comunitario, seguido de los 32 meses de régimen de prueba para personas que han cometido delitos de drogas.
The sentence is concurrent with the sentences imposed in case 20 CF 479, 20 CF 481, and 20 CF 482.
Y en los casos, la pena se debe poner de manera simultánea, tanto en los casos 20 CF 479 como en el caso 20 CF 481 y el caso 20 CF 402.
The conditions regarding the requirement to enter and successfully complete the Phoenix House program will be the same.
Y la misma condición de ingresar al Phoenix House, de inscribirse y terminar con éxito el programa,
Will be the same as announced in case 20 CF 479.
es igual en el caso 20 CF 479.
The fine court cost public defender lien will be in the same amounts as ordered in case 20 CF 479.
Y también en el caso 20 CF 479 tendrá que pagar las costas judiciales y los pagos a la Defensoría Pública.
And payable at $50 per month consecutive to the payments ordered in case 20 CF 482.
Y también será consecutivo con los cargos, el pago se cancelará en cuotas de $50 mensuales.
You have 30 days within which you can appeal the judgments and sentences that were just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal within 30 days of today's date, you waive your right to appeal. Do you understand?
Tiene usted pues derecho a apelar a los 30 días de que se imponga esta sentencia. Si usted no tiene cómo pagar un abogado para que lo defienda en tal apelación, un abogado le sería designado. Se cancelaría el derecho a apelar ya después de los 30 días que se imponga la sentencia. ¿Entiende?
Sí.
Yes.
Thank you, sir. Good luck to you.
Gracias, señor, y buena suerte para usted.
Thank you, Mr. Leal.
You're very welcome, Your Honor.
Okay. Ricardo Williams.
Your Honor, he's a high-risk inmate. He's in process of being transported up here.
Okay, that's fine. Then Frank Butner.
Kristen Frank on behalf of Mr. Buettner. Your Honor, we'd also be asking to waive the reading of the underlying.
Can't do that. Ms. Butner, if you'll raise your right hand, you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth.
Yes, sir, I do.
State your name, please.
Frank Bittner?
Mr. Bittner, you were placed on probation in case 6 CF 1941. Do you understand, sir?
Yes, sir.
And you understand what the charges were that you were on probation for?
Yes, sir.
The maximum penalty for those offenses is up to 35 years state prison. Do you understand?
Yes, sir.
Been accused of violating your probation. It's alleged that you violated Condition 7 by possessing or consuming, by consuming intoxicants to excess on or about January 20th of 2020, and that you violate Condition 5 by committing the offense of driving while under the influence on that same date. Do you understand?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 35 years state prison. Do you understand?
Yes, sir.
And do you wish to admit that you violated your probation as alleged?
Yes, sir.
Did you read and understand the written admission form?
Yes, sir.
Do you have any questions regarding anything on the written admission form?
No, sir.
Are you currently under the influence of any medication or other types of drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced or forced you in any way to enter this admission?
No, sir.
Your recommendation is that the court revoke and terminate your probation. You'd be sentenced to 7 years in the Florida Department of Corrections with credit for the time that you've previously served in the Department of Corrections in this case, plus all time served in the county jail following your arrest on the violation of probation. Is that your understanding?
Yes, sir, it is.
You've been represented by Ms. Cronk. Are you satisfied with her representation of you?
Yes, sir, very much so.
You believe it is in your best interest to enter the admission?
Yes, sir, I do.
You do have the right to have a hearing to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you'd have the right to be represented throughout the hearing by Ms. Cronk. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you have to be present at the hearing so you can present their testimony. You also have the right to testify yourself. You could choose to remain silent with respect to the allegations you committed a new crime while on probation. And you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as charged. You understand?
Yes, sir.
By entering the admission, you're waiving the rights we've talked about as well as the other rights on the written admission form. And there won't be any further hearing in your case other than a sentencing hearing. Do you understand?
Yes, sir.
You also are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
Now, given the age of the original case, you were probably not advised at that time, but you understand that due to the nature of the charges in that case, once you complete any sentence the court might impose in this case, you could be committed civilly for an indeterminate period of time as a sexually violent predator.
Yes, sir.
Okay. All right, I find that you're alert and intelligent, that you understand the nature of the allegations against you, the penalties you're facing, and the rights you're giving up by entering the admission. And find that your decision to enter the admission has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you said you were satisfied. Accept the admission in violation of probation. All right. What's the time served we have from the date he was after he?
157 days.
Does sound right? Okay. All right. I'll accept the admission of violation of probation. Ms. Cronk, do you agree the score sheet was 66.4 total sentence?
Yes, Your Honor.
Is there anything further to be said before sentence is imposed? All right. Mr. Bettner, I'll follow the agreed-upon resolution in your case. Having accepted your admission of violation of probation, I will revoke and terminate your probation. You'll be sentenced to 7 years in the Florida Department of Corrections with credit for 157 days that you've served in the county jail since your release from the Department of Corrections. You'll also be credited for all time previously served in the Department of Corrections or in the county jail awaiting the sentence, the original sentence. You are ordered to pay the outstanding financial obligations. It appears there's $100 that remains outstanding. There will also be a $100 public defender lien imposed for this representation in this matter. And the state is seeking $300 cost of extradition. I will order the restitution, the cost of extradition. I don't know if you want to agree to that amount or have a hearing. You're entitled to have a hearing to determine the reasonable amount to transport you here from Okeechobee County. The state's seeking $300. We can have a hearing as to that, or you can agree to that.
I don't believe there's any objection to the cost of extradition.
You wish to agree to the $300 cost of extradition, or do you wish to have a hearing as to the reasonable amount?
I'll agree that that's a reasonable amount, sir.
Okay, sir. So I'll order you to pay all the money that's owed at the rate of no less than $50 every month. You'll have until June 1st of 2022 to make your first payment, which will give you plenty of time to get out, get back on your feet before I start making those payments. Payments are made to the clerk on the second floor of the Osceola County Courthouse. You can pay in person. You can pay by mail, or you can pay online. All right? You do have 30 days within which you can appeal the judgment and sentence which just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal within 30 days, you waive your right to appeal. Do you understand?
Yes, sir.
All right, thank you, sir.
Thank you, sir.
All right, we have Mr. Medina Diaz. Yes, sir, raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, please tell us your name, sir.
Henry Medina Diaz.
Just for the record, Richard Mendoza standing in for Ms. Alicia Smith on behalf of Mr. Medina Diaz.
And Sheriff Adams for the state standing in for Ms. Shea on 20 CF 1010.
All right. Mr. Medina Diaz, you're here this afternoon, or this morning, in two cases. In case 20 CF 1010, a plea form has been submitted which indicates you wish to enter a plea of guilty to burglary of a structure with a battery therein as charged. Is that what you wish to do?
Yes, sir.
Okay. That charge is a first-degree felony, which is punishable by up to life in prison, probation for up to life, and/or a fine of up to $10,000. Do you understand?
Yes, sir.
All right. And in case 20 CF 1016, the plea form submitted by your lawyer indicates that you wish to enter a plea of guilty to petty theft with 2 or more prior theft convictions. Is that what you wish to do in that case, sir?
Yes, sir, I understand.
Okay. And state you be now processing counts 2 and 3 in that case? Okay. You charged of petty theft with 2 or more prior theft convictions is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes, sir, I understand.
All right. Mr. Medina Diaz, I've been given written plea forms in each of these cases, which appear to have your initials and signature on them. Did you read and sign the written plea forms?
Yes, sir.
Do you have any questions about anything on the written plea forms?
No.
Are you currently under the influence of medication or any other type of drug or alcohol?
No.
Are you thinking clearly at this time?
No.
I'm sorry?
No, sir.
You are not thinking clearly?
Oh, yeah, well, sorry, but yes.
Okay. Please, that's fine, but please listen carefully to the questions. And if you have an answer that's something you don't think I'm expecting, that's fine. Tell me what the real situation is. But you are thinking clearly today?
Yeah.
Okay. Has any person coerced or forced you to enter these pleas?
No.
Your recommendation in these cases is that in each case you'd be adjudicated guilty and sentenced to 5 years in the Florida Department of Corrections with credit for 65 days that you've already served. You'd be ordered to pay fine, court costs, public defender lien, and application fee, as well as restitution. Is that your understanding of the agreement? Is that what you believe the agreement is?
Yes, sir.
Okay. Okay, the clerk indicates that you're entitled to 66 days credit for time served, so the court would change that accordingly. All right, and state, to the extent this appears to be a slight downward departure sentence, are you recommending a downward departure sentence?
We are, Your Honor.
Okay. All right. Mr. Medina Diaz, are you satisfied with the representation you've received from the Office of the Public Defender in these cases? Are you satisfied with your lawyers?
We are.
Do you believe it is in your best interest to enter these pleas?
Yes, sir.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes, sir.
If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete the sentences imposed in these cases, you could be committed civilly as a sexually violent predator. Do you understand?
Yes, sir, I understand.
You have the right in each of these cases to have a jury trial to determine whether the state can prove that you committed these crimes.
Yes, sir.
If you chose to go to trial, you're entitled to a separate trial in each case. At your trials, you would have the right to be represented by your lawyer. You could not be found guilty unless the state proved your guilt beyond a reasonable doubt. You would have the right to confront and cross-examine any witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you have to be present at the trials. You also have the right at each trial to testify yourself, or you could choose not to testify, and if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand that you have these rights?
Yes, sir, I understand.
By answering these pleas, you're waiving the rights we've talked about, as well as the other rights that are written on the plea forms, and there won't be a trial in either case. You also, by answering these pleas, are waiving your right to appeal any matters relating to these cases other than this court's jurisdiction to hear the cases and the legality of these sentences imposed. Do you understand?
Yes, sir, I understand.
All right, I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing in these cases, and you understand the rights that you're giving up by entering these pleas.
Yes, sir.
I find that your decision to enter these pleas has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've indicated you are satisfied. I further find that there's a factual basis upon which the plea can be accepted in each case based on the arrest affidavit. So I'll accept your pleas of guilty, I'm sorry, I said no contest earlier. Accept the pleas of guilty. Mr. Mendoza, do you agree this course sheet with 109.2 total sentence points?
Yes, sir, no objection.
Anything further with respect to sentence?
None at this time.
Ms. Medina Diaz, in case 20 CF 1010, you'll be adjudged guilty of burglary of a structure with a battery therein. As charged in the information, the court will impose a downward departure sentence pursuant to the uncoerced plea agreement between yourself and the state. You'll be sentenced to 5 years in the Florida Department of Corrections with credit for 66 days' time served. You're ordered to pay court costs of $415, a $100 cost prosecution, a fine of $500, $100 public defender lien, and $50 public defender application fee. Money's ordered to be paid through no less than $50 per month through the Clerks Collection Program. The first payment we do by June 1st of 2025. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. In case 20 CF 1016, you'll be adjudged guilty of petty theft with 2 prior theft convictions, sentenced to 5 years in the Florida Department of Corrections with credit for 66 days' time served. This is a downward departure sentence pursuant to the uncoerced plea agreement that you entered into, and the sentence will run concurrent with the sentence imposed in case 20 CF 1016. You're ordered to pay court costs of $415, a $100 cost prosecution, a fine of $500, $2.14 in restitution to the Wawa store at 3140 Vineland Road, Kissimmee, $100 public defender lien, and $50 public defender application fee, all of which is payable through the Clerks Collection Program at the rate of no less than $50 every month, consecutive to the payments that were ordered in case 20 CF 1016. You have 30 days within which you can appeal the judgment and sentence just entered in each case. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand?
Yeah.
All right, thank you, sir. Madam Clerk, you have the misdemeanor also on Mr. Williams.
Yes.
Yes. Steve had earlier announced that. All right, Mr. Williams, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
State your name, please.
Carter Williams.
Okay, Mr. Williams, just a moment. Let me get your cases pulled up here. All right. Mr. Williams, you are here today in 3 cases. In case 19 CF 4102, and provide a written plea form that indicates you wish to enter a plea of no contest to delivery of cocaine within 1,000 feet of a school. Is that what you want to do in that case, sir?
Yes, sir.
All right. That charge is a first-degree felony, which is punishable by up to 30 years state prison, up to 30 years probation, and/or a fine of up to $10,000. Do you understand, sir?
Yes, sir.
Very well. In case 19 CF 4257, a plea form has been submitted which indicates you wish to enter pleas. It's not marked, but I'll mark it as no contest since the other one was. Pleas of no contest to possession of a controlled substance is charged in count 1, and possession of drug paraphernalia is charged in count 2. Is that what you want to do in that case?
Yes, sir.
Count 1 is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000, and it carries a mandatory 6-month driver's license suspension. Count 2 is a misdemeanor punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. You understand, sir?
Yes, sir.
All right. In case 20 MM 1080, you were placed on probation for 2 counts of threat to a law enforcement officer, public official, or family member, 1 count of battery, and 1 count of resisting an officer.
Sir, I went on probation, sir.
I'm sorry? Oh, you're not. Okay, yes, that's right. The plea form indicates you wish to enter a pleas of guilty to count 1 and 2, threat to a law enforcement officer, public official, or family member, count 3, battery, and count 4, resisting an officer without violence. Is that what you want to do in that case?
Yes, sir.
All right. And each of those 4 counts is a misdemeanor, which is punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand?
Yes, sir.
All right. Mr. Williams, did you read and understand the written plea forms in these cases?
Yes, sir.
Do you have any questions about anything on the written plea forms?
No, sir.
Are you currently under the influence of any medication or other kinds of drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced, pressured, or in any way forced you to enter these pleas?
No, sir.
The recommendation in these cases is that you would be adjudicated guilty of all counts to which you are pleading, that in the 2 felony cases, you'd be sentenced to 5 years in the Department of Corrections with credit for 80 days' time served. You'd be required to pay fines, court costs, public defender lien, and application fee, plus the 6-month driver's license suspension on the possession charge. In the misdemeanor case, you'd be adjudicated guilty of all counts, sentenced to a year in the county jail with credit for 77 days' time served, which would run concurrent with the sentences in the other cases. There would also be a fine, court cost, public defender lien, and application fee. Is that your understanding of the agreements?
Yes, sir.
Your Honor, just to note, in 19 CF 4102, 36 months of those 60 months are minimum mandatory.
Well, it's not indicated on the information, but, yeah, it is, okay. All right. So 36 months of the sentence in case 19 CF 4102 is the mandatory minimum required by law. Do you understand?
Yes, sir.
All right. Are you satisfied with your lawyers in these cases?
Yes, sir.
Do you believe it is in your best interest to enter these pleas?
Yes, sir.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes, sir.
If you have ever previously been convicted as a sexually motivated or sexually violent crime, once you complete the sentences imposed in these cases, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir.
Mr. Williams, you have the right in each one of these 3 cases to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
You'd have the right at each of your trials, and you're entitled to a separate trial in each case. You'd be entitled at each one of your trials to be represented throughout the trial by your lawyer. You'd have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you may have to be present at your trials to testify. You also have the right at each trial to testify yourself. Or you could choose not to testify, and if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. You understand that you have all those rights, sir?
Yes, sir.
By entering pleas of no contest and guilty in these cases, you're waiving the rights we've talked about, as well as the other rights are written on the plea forms, and there won't be any trial in these cases. Do you understand?
Yes, sir.
You also, by entering these pleas, are waiving your right to appeal any matters relating to your cases other than this court's jurisdiction to hear the cases and the legality of any sentence the court might impose. Do you understand, sir?
Yes, sir.
All right, Mr. Williams, I've read the booking reports or arrest affidavits in cases 20 MM 1080 and 19 CF 4257, as well as the affidavit for arrest warrant in case 19 CF 4102. Based on those affidavits in these cases, I find that in each case there's a factual basis upon which your plea can be accepted. I find that you are alert and intelligent, that you understand the nature of the charges against you, the penalties you're facing, and the rights you're giving up by entering the pleas. I find that your decision to enter the pleas has been freely and voluntarily made, and you've had the advice of a competent lawyer with whom you've expressed satisfaction. So I'll accept the pleas of no contest and guilty respectively. Mr. Mendoza, do you agree the score sheet was 91.5 months?
Yes, sir, we agree, no objection.
91.5 sentence points.
Sentence points, awesome. Thank you.
Is there anything further to be said before sentence is imposed?
No, sir, thank you. Oh, wait, actually, there is a note I have here, Your Honor. I don't know if the court would be inclined to grant Mr. Williams a referral.
No, I don't do that. So.
Thank you, sir.
Mr. Williams, in case 19 CF 4102, you'll be adjudged guilty of delivery of controlled substance within 1,000 feet of a school. You'll be sentenced to 5 years in the Florida Department of Corrections with credit for 80 days time served. 3 years of that 5-year sentence is the mandatory minimum as required by law. You'll be required to pay court costs of $415, a $100 cost of prosecution, a fine of $250, $100 public defender lien, and $50 public defender application fee, all of which is payable through the clerk's collection program at the rate of no less than $50 per month. You'll have until June 1st of 2025 to make your first payment. In case 19 CF 4257, you're judged guilty of possession of a controlled substance as charged in count 1, and possession of drug paraphernalia is charged in count 2. As to count 1, you'll be sentenced to 5 years in the Florida Department of Corrections with credit for 80 days time served. That sentence will run concurrent with the sentence imposed in case 19 CF 4102. As to count 2, you'll be sentenced to 80 days in the Osceola County Jail, credit for 80 days time served. In order to pay court costs of $415, a $100 cost of prosecution, a fine of $250, $15 pursuant to Florida Statute 938.13, $100 public defender lien, $50 public defender application fee, all of which is payable, that's rate of no less than $50 per month, through the clerk's collection program consecutive to the payments ordered in case 19 CF 4102. Your driving privileges are ordered suspended for a period of 6 months. The court has no objection to you obtaining a business purposes license if you otherwise qualify. In case 20 MM 1080, you'll be adjudged guilty of threat to a law enforcement officer, or family member, or public official as charged in counts 1 and 2. Battery is charged in count 3, and resisting an officer without violence is charged in count 4. As to each count, you'll be sentenced to 365 days in the Osceola County Jail with credit for 77 days time served. Those sentences will run concurrent with each other and concurrent with these sentences imposed in cases 19 CF 4102 and 19 CF 4257. You are ordered to pay a fine of $200 plus the misdemeanor court costs. That will total $483. There's an additional court cost of $201 pursuant to Florida Statute 938.08 and $151 pursuant to Florida Statute 938.085 for the battery charge. It'll be a $50 public defender lien and $50 public defender application fee. All of the money owed in the misdemeanor case is ordered to be paid at the rate of no less than $50 per month through the clerk's collection program, consecutive to the payments ordered in case 19 CF 4257. So, Mr. Williams, when you get out, it's going to be $50 monthly payments for starting June 1st that year for some period of time until you get all these cases paid off.
Yes, sir.
You do have 30 days within which you can appeal the judgments and sentences that were just entered in your cases. If you want to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
All right. Thank you, sir. Good luck to you.
Thank you, Judge.
Thank you. I believe that's all we have this morning. Do you have anyone we missed?
No, sir.
All right. Have a good morning. We'll see you at 1.
Hello at the jail. Can you hear me and see me?
Yes,
Are all the defendants in there? Yes, ma'am. Okay, I'm gonna go ahead and play the video.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se les comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Y a usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
You are here for
All right, good afternoon, folks. For those who are here for initial appearance, I have reviewed the arrest affidavits, and unless I indicate otherwise, when your case is called, I do find probable cause that you've committed the offense for which you've been taken into custody. In each of your cases, unless you indicate to me that you have private counsel or are hiring private counsel, I will be appointing the Office of the Public Defender to represent you. And that includes folks who may be held on out-of-county warrants. We'll start with our interpreter case. Anastasio Maria.
Good afternoon. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
All right. Good afternoon. We're here for initial appearance. We're first calling up Anastasio Maragildo Sarat.
He's approaching, Anna. Good afternoon.
Good afternoon. All right, good afternoon, sir. If you'll please tell us your name.
Buenas tardes, señor. Por favor, díganos su nombre completo.
Fernando.
¿Su nombre completo? ¿Apellido?
Fernando.
Fernando.
Okay, are you also known as Anastasio Emanuel Maragildo Sarat?
¿Usted también es conocido como Anastasio Emanuel Maragridet Serat? Señor, ¿usted también se conoce como Anastasio Emanuel Maragridet Serat?
No.
No.
Okay, and is
No.
this, who does the jail have this person identified as? I'm sorry?
Your Honor, may I inquire if he speaks Spanish or a dialect?
Okay, you can inquire.
Thank you. Señor, ¿usted habla español o usted habla algún otro dialecto? ¿De dónde es usted? Fernando. Your Honor, I asked if he speaks Spanish or any other dialect or where he is from. I did not get a response.
Right, he's standing mute, which is fine. Sir, you've been arrested for criminal mischief with damage of $1,000 or more.
Señor, usted fue arrestado por daño a propiedad ajena, daños en costos de más de $1,000,
Burglary of a structure,
allanamiento de una estructura,
resisting an officer without violence,
haber resistido arresto sin violencia
and making a false fire alarm.
I'm sorry, Your Honor,
Making a false fire alarm.
y haber hecho una alarma falsa de fuego.
Your bonds are set at $1,000, $3,500, $500, and $5,000 at this time.
Sus fianzas son las siguientes. En un caso tiene una fianza de $1,000, en otro caso 3,500, en otro caso tiene una fianza de 500 y en el otro caso de $5,000.
Do we have any prior history on this gentleman?
With this name? No, Judge, no history.
No.
Okay. Do we know if he-
Aparentemente no tiene historial.
Do we know if his identity has been confirmed through fingerprints or otherwise?
¿Sabemos si la identidad de este señor ha sido comprobada, ya sea por huellas digitales o alguna otra forma?
Judge, I tried to run his name through the immigration website, do not have any records of this name. And an officer assumes that he can find any information on this defendant through the system.
Okay, well, it appears there may be some mental health issues, but I've got some concern about who this gentleman is.
Hay cierta preocupación por el estado de salud mental y el juez está preocupado en tratar de determinar quién es esta persona.
All right, sir, based on the question as to your identity, I'm going to leave the bonds as set at this time. The Public Defender's Office is appointed to represent you. Ms. Broadway, I would consider other conditions of release if we can find out with certainty who this gentleman is. But I'm concerned at this point that we don't know that.
Your Honor, can we reduce the $5,000 bond or the $3,500 one?
I would reduce both of those if his identity is verified through fingerprints or otherwise.
Basado en la cuestión de la identidad del acusado, el señor juez está dejando la fianza en lo que se ha establecido. Por el momento se le está designando el defensor público. En cuanto a otras condiciones de libertad, tan pronto puedan verificar la identidad del acusado, el juez puede tomar esto en consideración para una reducción de fianza.
I will ask the jail to try to run his prints to verify identification. Ms. Broadway, if you have communication with with the gentleman, and there's some other way to identify him, that's fine too. If his identity is confirmed, you can have him brought back to initial appearance, and I'll adjust the bonds as to the burglary and the false fire alarm.
Señor, el juez ha ordenado que le tomen las huellas para tratar de verificar su identidad. El abogado defensor público va a poder hablar con usted si hay alguna otra forma de confirmar quién es usted y el juez pueden traerle nuevamente aquí para cambiar o ajustar las condiciones de libertad y considerar la reducción de fianza.
At this time, sir, you do have a lawyer. Your next court date is on demand in circuit court.
Señor, por el momento usted tiene un abogado y la próxima fecha de corte se la van a proveer más adelante.
Thank you, sir.
Your Honor, do we have a case number, please?
Yes, it's 20 CF 1633. The bonds are 1,000, 3,500, 500, and 5,000. All right, does
Thank
anyone
you.
else require the services of the Spanish language interpreter? If so, if you'll please come forward at this time.
¿Hay alguien más que necesite los servicios de intérprete? Pase adelante, por favor.
Looks like we have a gentleman coming forward. All right, what is your name, sir?
¿Su nombre, señor, por favor?
Rafael Ángel Ojeda Rivera.
Rafael Angel Ojeda Rivera.
Okay, one moment. Okay, it is, okay. Mr. Ojeda Rivera, you arrested on a warrant out of Orange County?
Yes, sir.
Señor Ojeda Rivera, usted fue arrestado por una orden de detención del condado de Orange.
The warrant was for failure to appear on a charge of driving without a valid driver's license.
Eso fue por haber faltado a corte en un caso de manejar sin una licencia válida.
Cierto.
Your bond is presently set at $1,000.
Su fianza actualmente es de $1,000.
Are you going to be able to post that bond?
¿Usted va a poder pagar esa fianza?
Eso con el 10%.
Is that with the 10%?
That's between you and the bondsman.
Yeah, yo estoy esperando, se supone que mi pareja estuviera pagando el bond, pero ella no sabe dónde estoy y yo no tengo el número de teléfono de ella, so no puedo ni yo comunicarme con ella ni ella saber dónde es que tiene que ir a pagar.
My partner is supposed to be paying that monies, but she doesn't know where I'm at, and I don't have a way to communicate with her. So she doesn't know where I'm located at.
Okay, well, the public defender's office is appointed to represent you. They may be able to assist you in contacting this individual.
La oficina de defensores públicos se le ha designado para que les represente, así que a lo mejor ellos van a poder asistirle con eso.
We'll also be reaching out to the Orange County judge to determine whether a lower bond would be agreeable to that judge.
También se van a estar comunicando con la oficina del juez en el condado de Orange a ver si el juez estaría de acuerdo a bajar esa fianza, la cantidad.
But if the bond is not reduced and it is not posted, you'll be held until Orange County comes to pick you up.
Pero si no les reducen la fianza, entonces va a quedar detenido hasta que el condado de Orange venga a recogerle.
The public defender's office is appointed to represent you while you remain in the Osceola County Jail.
La oficina de defensores públicos se le designa para que les represente mientras usted está detenido en la cárcel del condado de Osceola.
At your next court date in Orange County, the judge there will appoint a lawyer to represent you if you cannot afford to hire one.
Y en la próxima cita que tenga en el condado de Orange, el juez allá le puede designar un abogado si es que no puede pagar por uno.
Thank you, sir.
Okay.
Ms. Broadway, this appears to be a case in which the Orange County judge may agree to a reduced bond. I don't know if you have contact with your folks up in Orange, but we'll reach out to the judge individually as well. Right. Thank you, sir. Your next court date, will be in Orange County. Thank you.
Señor, su próxima fecha de corte se la van a dar en el condado de Orange. Gracias.
Okay, gracias a usted.
Okay, thank you.
Anyone else need the Spanish language interpreter? So if you'll please come forward.
They're indicating no, Your Honor.
Okay. Thank you, Madam Interpreter.
You're welcome, Your Honor. Have a great day.
You too.
Thank you.
Braulio Arce?
Your Honor, that was a case that was from last week. He was supposed to have been Baker acted. He's a Signal 20. He refuses to put a uniform on, or he refuses to come to court.
Okay, well, Mr. Arce is arrested on a warrant for making a false report or false report of a bomb threat. The bomb was set at 0. He was released on his recognizance on the related counts to have him Baker acted, but he's still in the county jail.
Yes, sir.
Judge Crystal Allen for the state. I've spoken with law enforcement. He was in fact released from the Osceola County Jail last week, was Baker acted, was taken to Park Place. This is a new offense that has taken place and a new warrant that was served on him.
It's a new warrant. The
Well, yes, not a new offense, but this is separate from, so he was in fact released from the jail to Park Place and was there for 48 hours.
So, well, he's entitled to a bond or other conditions of release being set in this case. What's the state's position?
Judge, obviously there are some significant mental health issues. The concern the state has is he also does appear to have a lengthy prior criminal history, and the state has concerns about the allegations in the report. Is he absolutely not eligible for any kind of mental health pretrial release?
No, he's not eligible for any pretrial release, I don't believe, at this time, because of the...
He's not, Judge, because of the open cases.
Right. So it's either an R. Do you have any questions at all about anything on the written plea form?
No, sir.
Are you currently under the influence of any medication or other drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Did any person coerce or force you in any way to enter this plea?
No, sir.
And what's the time served in this case?
223 days.
The recommendation is that you would be adjudicated guilty of each of the 5 counts to which you are pleading. As to count 1, you'd be sentenced to 5 years in the Florida Department of Corrections with credit for 223 days that you've already served. As to counts 2, 3, and 4, you'd be sentenced to 1 year in the Florida Department of Corrections to run consecutive to the sentence imposed in count 1, but concurrent with each other, followed as to each count by 4 years of drug offender probation. As to count 5, you'd be sentenced to the time that you've already served. As conditions of your probation, you'd be required to pay a fine, court costs, regional conflict counseling, public defender application fee, and restitution. Is that your understanding of the plea agreement?
Yes, sir.
All right. Did anyone promise you anything else to get you to enter this plea?
No, sir.
You've been represented by Mr. Zaleski. Are you satisfied with his representation of you?
Yes, sir.
Do you believe it is in your best interest to enter this plea?
Yes, sir.
Do you understand that if you are not a United States citizen, entering this plea will subject you to deportation?
Yes, sir.
If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete the prison sentence imposed in this case, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir.
You do have the right to have a jury trial in this case to determine whether the state can prove that you committed these offenses. If you elected to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty of any offense unless a jury unanimously found that the state had proven your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
If you elected to go to trial, at your trial, you would have the right to be represented throughout all proceedings by Mr. Zaleski. You would have the right to confront and cross-examine any witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense at trial. You are entitled to have this court order any witnesses you have to be present at the trial so you can present their testimony to the jury. You also would have the right at your trial to testify yourself, or you could elect not to testify. If you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand that you have all of those rights?
Yes, sir.
By entering a plea of no contest, you're waiving all the rights that we've just talked about, as well as the other rights that are written on the plea form that you signed, and there won't be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
Very well. Mr. McMillan, I've read the affidavit for arrest warrant by Detective Yakub. Based on that affidavit, I do find that there is a factual basis upon which the court can accept your plea. I find that you are alert and intelligent, that you understand the nature of the charges against you. You understand the penalties that you're facing as well as the rights that you're giving up by entering this plea. And I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've expressed satisfaction. So I'll accept the plea of no contest. Mr. Zaleski, do you agree with the score sheet of 64.5 total sentence points?
Yes, Judge.
Is there anything further to be said before sentence is imposed?
No, Judge, I know that the state has provided a letter from the victim for you to read, but nothing else other than that.
Okay. I do have a letter or email from the alleged victim here.
Jade Delaire, I believe.
All right, anything further then with respect to sentence?
No, Your Honor.
Mr. McMillan, I will follow the recommended disposition. You will be adjudged guilty of the lesser included offense of robbery as to count 1, aggravated assault with a deadly weapon as to count 2, fraudulent use of a credit card more than 2 times in a 6-month period as charged in count 3, unlawful possession of a stolen credit or debit card as charged in count 4, and petty theft of $100 or more as charged in count 5. As to count 1, you'll be sentenced to 5 years in the Florida Department of Corrections with credit for 223 days time served. As to counts 2, 3, and 4, you'll be sentenced to 1 year in the Florida Department of Corrections. That sentence will run consecutive to the 5-year sentence imposed in count 1, but the 1-year sentences as to counts 2, 3, and 4 will run concurrent with each other. They will be followed as to each of those counts by 4 years of supervised probation. That's as to counts 2, 3, and 4, again running concurrent. As to count 5, you'll be sentenced to 223 days in the county jail with credit for 223 days time served. It'll be a condition of your probation that you pay court costs of $415, a $100 cost of prosecution. There'll be a fine of $500. $100 regional conflict counsel lien, $50 public defender application fee. I will order restitution to J. Joseph Delaire and reserve jurisdiction to determine the amount of that restitution. The restitution will be joint and several with the co-defendant should he be convicted of his part, or if he has been convicted, the restitution is joint and several. You'll be required to report to the probation office here in Osceola County no later than 2:00 p.m. on the next business day following your release from the Department of Corrections. The money that's owed is ordered to be paid at the rate of no less than $50 every month, beginning no later than the 4th month of your probation. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. Is there anything further with respect to the sentence?
No, Your Honor.
Mr. McMillan, you do have 30 days within which you can appeal the judgment and sentence was just entered in your case. If you wish to appeal and you are unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
All right, thank you, sir. Good luck to you. All right, are we ready on Mr. Hill's case?
Mr. Hill,
Okay.
Mr. Rosado for the state.
Good afternoon, Mr. Hill. If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please state your name. Okay, you can put your hand down, sir. Ms. Broadway, the state has filed an amended information. Before we proceed with the bond hearing, did you wish to waive arraignment and enter a plea of not guilty as the amended information? Okay. And is this case in this division, or is it 301? Okay. So we'll accept the plea of not guilty as to the amended information. And do we have,
Already entered a plea to the original information, so the case could remain as that.
okay, it's set for pretrial on August 26th with a trial period beginning September the 8th. With respect to the bond hearing, I note that there are some counts listed at no bond on the, at initial appearance. It appears that your client be entitled to a bond being set. So the question is what the reasonable amount would be, I think.
Correct.
Did you have any evidence or testimony you wish to present, or just argument?
Just argument,
State any evidence or testimony, or just argument?
Judge, yes, if I can approach, and defense has no question.
Okay. I'll take
I believe the memo that the state has provided the court was actually previously filed in Benchmark around the same time that the initial appearances took place.
Okay, let me take a moment and read this. All right, then argument, Ms. Broadway.
Yes, Your Honor. With respect to the information that the court just read, it appears that the alleged victim in this case and the two co-defendants would have very different stories with respect to what happened and the nature of what happened during the encounter in the hotel room. With respect to the amendment of the state file, I would ask that the court set a much lower bond with respect to the counts because those are directed at years of co-defendant, foster, even in the state's file. I still believe that the court should take into consideration these are actions which the co-defendant would have performed. Your Honor, I've spoken to Mr. Hill's mother. She is the one who's going to be posting his bond. Ms. Hill has provided the address in which Mr. Hill resided. What she can afford right now is $200 cash. We do realize that for the charges, it is a lower amount for the bond, but we would ask the court to take into consideration the financial resources that she has. Mr. Hill will abide by any conditions that the court imposes, and that if the court set a reasonable bond, considering what the family can.
Thank you. State.
Judge, the defendant can be charged with the acts committed by the co-defendant as a principal based on the multiple perpetrator statute and enhancement which was filed by the state. The defendant admits to at least one of the counts. He stated that he asked the victim to perform oral sex on him. She refused, however, he still forced her to perform oral sex. The defendant is entitled to a bond. We are asking for a higher bond. The defendant has a failure to appear, 1 in 2007, 2008, 2009, 4 in 2014, and 2 in 2016, for a total of 9 failure to appears. Obviously, the bond is to ensure his attendance for the next 4 days. We do not believe he will appear for court, and if I may approach with a score sheet. I've seen the score sheet, Your Honor. So based on the fact that he is looking at 4 first-degree felonies as well as his criminal history and his failure to appear, the state is asking for a $5,000 bond on each count.
All right. All right, I will set bond in the amount of $15,000 as to each count. It will be conditioned upon the defendant having no contact directly or indirectly with Barbara Ann Armstrong. Impose any other, or with the co-defendant. Pauline Natasha Foster. Thank you. Turn these documents in the state. All right, thank you, Mr. Hill. All right, Mr. Mendenhall. How about Derek Brown?
Derek Brown, Your Honor. I contacted the bondsman. The state's offer.
Yes. Yeah, we'll pass it for a moment. Yes, have a good afternoon. So you want to address the other one first, then? Okay, then we have Lazaro Macias.
Macias. And I'm trying to secure, negotiate with the state to get him something that would release him from jail. They'd like a chance to talk to the victim. I think we're going to work out something. They've given a 10-month Orange County jail offer up front, or that's something closer to time served. I'm also opting perhaps in the case that he has and secure a probation offer. Could we keep it in this trial period and put it out another week?
I pretty strongly prefer to get the case, if it's going to be resolved prior to the beginning of the trial period. I don't have any problem doing it at the end of this month.
Okay.
So he's got an Orange County case that's pending, and you're trying to do a global resolution, is that?
No. Well, it's just this case that's pending. The state wants to be able to notify their victim potentially to be in jail. And I'm trying to negotiate probation as well.
Okay. Let's reset Mr. Macias then. Good afternoon, Mr. Macias. State your name, please. Mr. Macias, I'm going to reset your case for a status hearing / plea on June 30th at 9:30. Now, if you resolve things earlier than that, we can certainly move it up.
And I'll be trying to get that done.
Okay. So your attorney's going to try to get everything resolved before that, and we can move you up if he's able to do that.
Thank you, Mr. Moore.
Thank you.
And can I have a minute, Mr.
Sure.
Brown?
Absolutely.
Mr. Brown, I'd ask to leave him on your trial docket.
Okay.
Eric Demetrius Brown.
All right.
Your Honor, I'll just put on the record that my last day in this position is going to be 10 days from today, on the 18th.
Okay.
At that point, a new prosecutor's been taking over and I'm going to go all off.
All right. So Mr. Mendenhall will set Mr. Brown for trial on July the 13th. And just be aware that any plea offer that's been made is only valid as long as Mr. Kazera is the prosecutor, and he's no longer going to be the prosecutor in 10 days. What's the date, your last day?
18th is the last day, Judge.
Okay, so June 18th, it's actually Thursday, but, okay. Friday, the 19th, it looks like would be the last day that plea offer is available, so. All right, so Ms. Brown, once you get your paperwork from the clerk, you're free to go today. Make sure you keep in close contact with Mr. Mendenhall between now and the time of your trial, sir. All right? Thank you.
That's it.
Thank you.
That's it for me.
Yes, have a good afternoon.